was assembled to provide quality housing in the area that had not existed in the past. In 2014, 13, and 14, our code was revised to encourage redevelopment to occur within this area. And that revision to the code occurred that extends beyond this particular area, but all the way from Andrews west to 24th Avenue along the Cistron Boulevard corridor. The developer took the leap of faith to invest in this area to provide what has now become the trademark for that particular corner. That corner, if you may or may not recall, was vacant for a number of years. The outreach that occurred for this product and project was extensive. The original language or the original designation for this site was West Village. After meeting with the community, the development team determined that, based on conversations that was had with the community leaders, that we changed the name to the Adderley. Now that's sort of significant because it was changed to represent an individual who is from this community, who was a very famous jazz musician. And being on the Avenue of the Arts, we felt it was appropriate to change the name from West Village officially to the Adderley. So what you see today is a result of those community outreach initiatives. The project consists of 417 units. Originally, going in from the, and after it was reviewed and approved by the Community Redevelopment Agency, as well as the City Commission, the commitment was 10% of the units will be devoted for workforce housing. Because of the desire to make sure that efforts are being made to accommodate the future vision of the city of Fort Lauderdale, excuse me, over 50% of the units are now workforce housing. And that's been done as an incentive to create some energy and to create a different product that will be available to the area. I want to go through the slides very quickly to talk about, just to refresh those of you who may or may not know. This, if you can just go to the next slide, please. This is the development. This is looking at 7th Avenue and Cistron. Can I? I'm sorry. Well, I'm new at this, so please, after. I need a little bit of some assistance because I'm not familiar with this. I came up in the old school when we had slides that all you did was just, we had Polaroid pictures and things of that nature. So it isn't me. Thank you. Appreciate it. Thank you very much. Okay, so this is a look at the 7th Terrace side. I'm sorry, this is a look at the 7th Avenue side, which is on the corner of 7th and Cistron. And I just go through these very quickly. This is the artwork that was provided for this development, the station, electronic station area. Now, I do want to get into this, and I want to, the quality of this development exceeds anything that I've ever seen, and from a workforce housing perspective. This is high quality development for the area. These are the typical unit styles that you see here. I'll be very quick. This is the common area, more common area. Office space for individuals who want to go in and spend some time away from their unit and do some office work. More common space within the lobby. You look at this artwork that you see there will be duplicated basically on the outside because we want to feature the Avenue of the Arts. And this is actually from an album that Cannonball Adderley produced many, many years ago. This is the mailing center. Again, common area, recreation area. This facility has a 2-lane pool, a bowling ball area, so you can do bowling. This is a rooftop feature that entertainment activities are held up in that area for the residents and for also for people from the community who want to come in and do some and have some kind of event there. That's available. That's a gorgeous view. If you ever have an opportunity to go, I would encourage you to go and just look at that view from the top floor. This is another view of that area. This is a workout room that I probably should attend, but I probably won't. This is some of the outdoor common area for the residents. As you can see, nothing was spared with the quality for this residential development. Now, we're here today because we've gone through DRC, we've gone through permitting, and there are approximately 40 plus structures on top of this roof. Of the 40, and you'll see from the of the 40, there may be 2 to 3 that are visible from a distance. When you get on the site, and when I say a distance, I'm talking about blocks away, blocks and blocks away. So less than 5% of the total number. And this didn't occur. We were not notified of this until we were in for final inspection. So we went through the permitting process. We were able to install these units. Many are set back so far that they don't even reach the need to be screened. But at the end, when we were ready for our CO, we were told there were a couple of units that didn't meet that requirement. But you can't see them when you're at the site at all. So we believe we meet the intent of it, and we think that this particular initiative to see this development continue to move forward is essential for not only for the development team, but for the residents of the city of Fort Lauderdale. I have with me the Altice representative, Frank Guerrera, who's the major representative, as well as Mauricio Gurdian, who are also here with me this evening to answer any questions that you may or may not have with regards to this request. Thank you very much for your time.
Thank you, Greg. I'm going to open up the public hearing. Is there anybody from the public wishing to speak to this matter? Okay. Seeing that there's none, I'm going to bring it up to the board. If there's any questions of the applicant, Greg, don't go too far, just in case we have some questions. Any questions of the applicant? Doug?
You didn't show any pictures of the problem.
Oh, well, let me make sure I get to it. I do apologize.
I mean, it's a lovely building, but that's not.
I understand. I truly understand your position on that. Do we have, is it in there? Do I just need to keep going? Because it seems like I've gone through this already.
Well, I looked at the photos in the submission, and I didn't see, your description says there's drop downs and architectural lower areas. You said that's the only issue or problem, but looking from your submission, I'm not really seeing where there's a lot of lower areas except, 1 or 2.
Well, yeah.
So,
yeah, we were talking basically on the design. When we went into the city for our review for the building itself, being that it was more than 200 feet in length, we stepped some sections of the building back to create an architectural break.
Down or just back?
Back and out, yes. Yes, but the roof line itself is the same. That was reviewed by the design review committee, and we responded to every comment that they had with regards to the.
You're saying some places are a couple inches, some places are 3 feet, because the way I read it was power pit. So lower,
no, that's the unit itself. I'm sorry, that's a mislead. The units are at a certain height, and they vary in their heights in terms of how they've been installed. Not the screening itself for the building.
Obviously bigger units. Okay. So also, if I was at, 5 feet, 6 floors, 5 floors, if I'm in a building across the street, the same height, apartment, am I seeing the units or am I not seeing the units?
Not at all. You would see it. I'm sorry.
Sir, just announce your name in relation to the property.
Yes, my name is Frank Guerra. I'm with the West Village entity, and we are the development company and the owner of the property, together with the various partners, including the CRA, which is involved in this project as well, which we're very appreciative for, and has been a great relationship. To answer your question, sir, at the end of the day, there is a parapet there. And this is really just a technical question about how much higher than the units the parapet needs to be. And in some cases, we're talking about a 6-inch, variance from a technical difference. But in our case, our units are set back as far back as 33 feet from the edge. That's why from anywhere in the proximity, you don't see these units.
So let's talk about the ones you do see.
No, that's my point, is that you standing on the ground level, you can't see them from anywhere.
Well,
And
that's not what your submission says. That's not what your submission says.
No, I think, no, well, I'm talking about at the ground level, anywhere within a couple of block radius. You'd have to go back like 5 blocks to be able to get an angle to be able to see some of the units, which are a little bit taller than other units, which are lower.
Maybe I can explain what you're seeing with regards to the request itself. The code requires it to be a certain height below the parapet. What our request is that there's certain areas on there, regardless of where it's located. You can't see it, but it doesn't meet that height. We're set back so far, but it still doesn't meet the height of the parapet that's required to be lower than the parapet requirement.
Okay, but in your submission, okay, you said there are certain number of ones you can see, and you have a map of how far away you have to see them. So let's talk about the ones that you said you can see. Okay, the way I read it was the parapet. Now you're telling me that the units are different heights. So in your submission, you said some of them are 3 feet over. Well, that's a pretty big unit.
No, they're 3 feet. Yeah, it is. It is 3 feet when you set them back, but the parapet wall itself is at a height, right?
Right.
The unit is at another height.
Right.
And it may be 3 feet above what that height is that's required by code, but you can't see it because it's set so far back. Staff has said to us it doesn't matter if you can see it or not. It doesn't meet the requirement because it has to be set back according to the code. It has to be lower according to the code. You can't see it, but it's higher than the code allows, is what I'm trying to say.
I understand that. But you're saying in your submission that there are units you can see.
Well, again, I think if we go to the photo, it may be one that you might be able to see from a distance. We're trying to get that photo up from you because there's a photograph of one that if you're far away, yeah, yes.
And how far away was that taken?
Let me make sure I'm looking at the one.
I think this is the one you're talking about, isn't it? Because you can see that.
Yes. So that the property, we're about a
Go back
block and a half to 2
Mike.
blocks. I'm sorry. That's standing on just about 4th Street. And the property is on Sistrunk
Okay.
and 5th.
So if I was in this building, I'm not sure. If this building across the street is my same height, and I'm on the apartment across the street, how many of these units do I see? Do I look at all of them? Do I see one that's close and see nothing else?
You see, the code only requires you to be there's only about two to three of them that are not, and again, if you're looking straight across, you only see the ones that would be higher than the code requires for that particular location. But it's set back. You can't, like if I'm up high enough, just like anything else, if I'm up high enough, I'm going to look down and I'm going to see those units.
I'm not saying looking down. I mean, that's not fair.
If I'm looking straight across, you're going to see exactly what you're seeing if you're at that distance that we're talking about there.
Anything else, Doug?
No, thank you.
Okay. Anybody else have any questions about the applicant? Okay. With that, we'll close the public hearing and bring it back to the board for a vote. Thank you.
A motion?
Yes, please, Pat.
Okay, I make a motion. Let's see. That we grant the variance request from 47-25.3A3B3 and 4719.2Z1 because the applicant has met the criteria for the granting of the variance in that the circumstances causing the special conditions were not caused by the applicant, and that the rooftop configuration of this project, which has been ongoing for many years, are different from other buildings in the zoning district, which have more flexibility.
Okay.
Can I ask a question?
Let me see if I have a second first. Do we have a second?
Second that.
Okay. Discussion. Go ahead, Doug. Microphone.
How is it different?
Because
May-
they started designing this before the code changed, and they were well into building it or build it before their final. From my understanding, the final inspection is what caught that this was a little too high.
But how long ago was the rule changed? They're only going for the CO recently. How long ago did this code change?
The design of this building started in 2017 or something like that, 17, 18. As property was being assembled, we met with the city staff. I think it would have been August or September of 2017, 2018, somewhere in there. My recollection.
Okay, a staff question. At what point do they have to meet newer codes? Does this change before or after that?
I'm trying to look up right now to see when the permit was submitted, and then I can answer that question.
Okay.
Well, and I can also add additional justification for my motion, which is that the variance is the minimum necessary to give them the reasonable use of the property. The building's built, the units are there. To require them to tear them out and start
No,
over
that's not
again.
okay, if I may, sorry to interrupt, but what would, just curious, but if you put up screening, what does that mean? Are you putting up like a little fencing around with screening, or?
no, it's much more than
I mean,
that.
I'm not imagining you have to take the units out. I mean, what is
No.
HVAC screening that's acceptable to the code?
It would be to screen. This is an entire city block project, right? The entire rectangle. So it would be putting a uniform screen along the perimeter of the entire project. So it's a very large scale. You know, it's not just putting one screen in one area where there's this one unit. Obviously, that would make the
unit.
project look a little bit awkward. So it's kind of an excessive way of addressing what is only a couple of units, but that would be the way to interpret it. And to tell you the truth, seeing the edge of a metal screen, especially from a several block away vantage point, it's really no difference than seeing the corner of the edge of a air conditioning unit, right? I mean, it's kind of the same thing. It's a metallic panel, which whether you detach it and put it on the parapet or whether it's the edge of the air conditioning unit itself, it's not really a material difference. But it would be a very material difference to the project, which is a cost-sensitive project because of all the workforce components of it, to cover the entire perimeter of an entire city block project with fairly expensive metal screening, which has to meet wind load testing and hurricane, impact analysis.
Okay, so that would be so either doing that or doing every unit would be to meet the requirement.
And also, I do want to add, as I said earlier.
Give me one second, Greg. Bert, do you have your answer? Bert,
He's looking.
you have your answer or not yet? Okay.
I'm sorry.
Go ahead, Greg.
I do
While we're-
apologize.
take
I'm
your
sorry.
time.
No, do want to add that there are 40 plus structures on this site. We're talking about screening that exists for, I would say, 95% of or more. And this just happened to be these 2 or 3 units. Although they're set back, they don't meet the maximum height.
Thank you.
Anything else, Doug? Do we need Bert to still look?
Chair, if I can ask for clarification from the gentleman is represented as the architect of the project.
Go ahead.
No,
So
he's the owner. He's
the owner?
Yes.
Greg, maybe you can clarify. In the backup material, there is shown a 5-foot parapet. Is that around the entire exterior of the building?
That is what's in place today, yes.
So the 5-foot parapet.
Yeah.
And so that does screen material on the roof of the structure.
It screens pretty much everything. So if you were standing on the sidewalk across the street from the project, you literally can't see anything. So if you go I'm sorry?
No, go ahead.
Yeah, so the point that Greg was making is that if you go back far enough, like a couple, 2 or 3 blocks away, there are like 3 units where you could maybe see the corner of a piece of the air conditioning unit, but not the unit in its entirety by any stretch, because there is a fairly large parapet that runs along the entire perimeter of the property. The solution that would be in question here would be raising that parapet for the full perimeter of the city block project.
Thank you. So, Chair, what I wanted to clarify for the board is the 2 code sections that they're seeking the variance from require the screening to be 6 inches above the highest point of the mechanical equipment that's on the rooftop. So that would require extending the 5 feet, maybe in some cases up to 12 or
The highest part is 311.
highest part is 8 foot 11
3 foot 11.
on the exterior of that building. So I guess the question for you is whether or not in terms of you're doing your hardship consideration, but I think what's being presented to you is that the 5 foot parapet actually adequately screens it for the most part, with the exception of the distances that they've reflected in their package.
Okay, Bert?
So the code changed in 2020, and what it used to say in the rack was that it had to be screened from view from the street. So as you were looking, if you're beside the building, you look up, you can't see it. It changed in 2020 to be the 6 inches above the highest point of the highest piece of equipment. And the permit was submitted in 2022, 2 years after the code changed. So that's why they're here for a variance, because they do have to meet that code section.
Okay. Anything else, Doug? We still have a motion on the floor, still discussion.
Okay, so is it possible, how many units are the bigger units? Out of, you said 40 units, how many are 3 feet higher versus a couple inches?
I believe it's 3 units, but they exist in the condition that they exist for a reason. Like there are some that are lower and wider, and these had to be taller and more
No, I'm
slender.
not asking about changing them, I'm just wondering
Because-
if,
well, I'm just-
if they're a handful, okay, can the answer be, these they have to screen locally as opposed to the entire building, as opposed to screening all 40? And do you actually see these, or are they so far in the middle of the building you don't see them?
They're 33 feet back.
These are 33 feet.
Yeah, I
So
mean, that
none of these are
is-
near
No.
the edge at all?
No.
So the closest unit is 33 feet back from the edge?
One of the ones we measured was 33 feet. The other one may be, 30 or
But
29. But I mean,
it's not 3 feet, it's not
no,
5
no,
feet.
no. It's nowhere near.
Okay,
Nowhere near.
okay. Thank you.
Do you guys have any renderings or anything of the aesthetics of this screen? Because I think that should also be considered if it's going to look worse. Like it looks great, but I'm saying if it's going to look bad, then
The
why?
screening, you mean
Yeah.
the screening that's there now?
Yeah,
That's
well,
already installed?
if there has to be additional.
Oh,
No.
oh, you,
That's why we're here.
Yeah.
We've been. The intent
No,
was to
I-
not have to
Of course.
do that kind of screen, but it would be a metallic screen.
Yeah. Okay.
Basically.
Yeah, so-
like you've seen cladding some garages and things
Absolutely.
like that.
Yeah.
So, and to us,
Around
it's
the
really no
entire building.
difference, especially since it's only in a couple of instances.
Yeah.
But I think it would look worse to put a metal screen around the entire perimeter of the property than to have these very unique conditions that you can only see from very, very far away. I mean, that's kind of why we're here.
Okay, well, we still have a motion on the floor, so let's see if we're going to table this
I got
motion.
one
or
more
if we're gonna keep on
question,
going.
sorry.
Go ahead, Doug.
Question, staff
There's a
question.
second.
Is the whole point of the screening visual, or is it also noise or anything else that's trying to be accomplished by screening the units?
It's visual.
Okay, thank you.
Okay, thank you, Doug. Okay, so we still have a motion and a second, but Pat, did you alter your motion? Or are we still good the way we are?
No, my motion is the same. I just added additional justification for my motion.
Okay, thank you. So we have a motion, and Jared, you were the second.
Yes, second.
Okay, great. No further discussion. Let's take roll on that, please.
Mr. Shedman,
Yes.
Mr. Galis,
Yes.
Mrs. Williams,
Yes.
Mrs. Rathburn,
Yes.
Mr. Mead,
Yes.
Chair Elfman.
Yes.
Motion passes.
Thank you.
Thank you for your time. I appreciate it. Thank you.
Thank you, board members.
Thank you. Next case, case number 250700003, 423 Mola Avenue. Let's start with disclosures. Jay?
I received a call from applicant's counsel.
Okay. Doug?
None.
Okay. Daniela?
None.
Oh, Jared?
I received a call from council.
Pat?
Nothing.
Okay. And I had both done a site visit and I spoke to council.
I did get a call, but I didn't take it.
Okay. Andrew, welcome back.
Thank you.
Okay.
Chair,
Yes.
I did have a conversation with Mr. Mead about this project, right? No, not this project. Well, it was a different one? Okay, thanks.
Okay. Thank you, Doug.
I wasn't talking about this project.
Good evening. Good evening, Chair, members of the board. Andrew Shine, representing the property owner. We were here in August for the actual hearing, and this was deferred in November as well. Nothing substantive for the deferral in November, besides my personal. I couldn't make that hearing. We were here in August for this, and we heard neighbor input, and we've been working with a lot of the neighbors over the past couple of months to come to some type of resolution and change the plans to really fit most of their concerns. I know there are some new members of the board, so I'll do another full presentation, but still keep it brief.
Do you think we need more than 15 minutes, Andrew?
No.
Okay, good. Then I'll give you 10. Go ahead.
The property is located at 423 Mola Avenue, and Mola Avenue is one of the most unique rights-of-way in the city. It is not considered a street due to the width of Mola. It's only 15 feet wide, and I don't know, I forgot who did site visits and who didn't, but it's a very unique street. And this happens to be a uniquely shaped property on a unique street. So that's just to start and give the overview of Mola. 15 feet is not enough for two cars to pass by each other, which is a lot of the neighbor issues here, and it affects drainage with just the whole street design. And we'll get into some of those concerns. This is what we presented at the last hearing. We were requesting a front setback variance for 5 feet instead of 25 feet. And that sounds like quite a large variance until you look at other properties on Mola. Again, because Mola is treated uniquely. Some properties are set back, between 0 and 1 feet from the street there. Others are set back 5 feet. Very few, if any, meet the actual 25-foot setback. Again, because Mola is unique. At the last Board of Adjustment hearing, I noted down 4 major concerns. One was the ability for parking to overflow into the right-of-way. If you can see here, there is a 2-car parking garage, but the front of the layout of the house doesn't really lend itself to that many cars being parked there. The second one was the width of Mola Avenue, which I spoke about. It's only 15 feet wide. Adding another house there can't really help that. The third was a drainage and flooding issue. Mola Avenue floods. There's no doubt about that. New houses on Mola have to retain all of their own stormwater on site. It's a county and city requirement. So even if you're building a new house there, you have to, any rainwater that hits your property legally has to be retained on site. If it's not, you got problems with both the city and the county. So the house itself will not really add any additional flooding to the street. But Mola is a low street. It needs to be raised. We're willing to contribute financially to raising it. We, of course, support raising it. But at the end of the day, it's a city right-of-way, and that issue is not fully related to what we're here for tonight. But we do support it. We will financially contribute to it. Ultimately, the city's got to be the one to raise it. And the fourth neighbor concern was that the building was too close to the street, which was an obvious concern at that point. This is the new plan, what we did. There were discussions about pushing the house back at the last hearing to make a bigger front setback. And I did mention that if we do that, we're going to have to request, we were there for one variance, a front setback. But the front appeared to be a major concern, whereas I discussed with the board and with neighbors, moving it back, and we'll need a rear setback variance, and we'll need a variance for the pool and a variance for the freestanding shade structure that wasn't previously needed. But the rear didn't seem to be as much of a concern. So we felt comfortable just pushing it back and giving now a 15-foot setback. The 15-foot setback is really only at the pinch points on the bottom of this plan on the left and right. The average front setback is a little over 20 feet. So we're only asking for that front setback at that pinch points. As you can see, we now provide spots for 9 cars. The city requirement is 2 cars for a single family home. So we're significantly exceeding that. And we also are proposing something unique here with MOLA. It might not work out if only our property does it, but it could alleviate some of the concerns. And it's the cars passing by each other. That highlighted orange area on the bottom, we're not doing anything to that area. We are proposing pavers now if the city allows us to, but we're not putting any structure in it, no landscaping in that area. And the goal is to expand Mola Avenue by 2 feet there, or at least allow the neighbors and public to use part of this property to navigate around. And that's for, street widths are measured from the center line generally. So if our neighbor across the street did that same 2 feet, now they'd have 19 feet, which is enough for 2 cars to pass by each other, which is minimum 18 feet or so you need. So we're adding that extra 2-foot buffer there that we'd be happy to dedicate to the city as a right-of-way easement. We'd be happy just to let people cross over it if they want to. But we did that to alleviate, at least on our portion of the street, that concern. We can't really do anything to the rest of the street. This is the 3D views. It's essentially the same as it was before, just pushed back. I think it's important to go through the variance criteria here one at a time. And I'm going to kind of combine the first and the second. The first is that special circumstances and conditions exist that prevent the reasonable use of the property. And I'm going to be using the word reasonable today. It's in the criteria. There was discussion, can you shrink the house a little bit? Can you move it back 1 inch, 2 inches more? And when we talk about reasonableness, you could build a tiny house on this property. One of those, I don't know what channel it is, but a tiny house. You could do that on this property without any variances. But the question is that reasonable? And my thought on what is reasonable for this property is, does it fit with the neighborhood? Are you building a house that's half the size of your neighbors or double the size of your neighbors? Then it's probably not reasonable. In this house, it's a large house. Don't get me wrong. Mola is an expensive street. There are, massive 11,000 square foot houses on there. And this house is about 6,000 square feet. So it's not small, but it's also not out of line with our neighbors. There are 67, right just to the north of us is a 6,700 square foot house, more 5,800 square foot houses. So that's my definition, at least, of reasonable. Are you going to look out of place in the neighborhood? And this property will not look out of place in the neighborhood. The city also has criteria for how much of the lot you can take up. There are 2 criteria. One is lot coverage, which is just the percent that a building sits on the property. And the second is floor area ratio, which takes into account second floors as well. And we meet both of those. So that's generally what architects and home designers use to not necessarily max out the square footage, but to use as a baseline of first what the city allows, but also what's going to be built around you in the future, because a lot of people do try to max it out. And we're within the FAR, we're within the lot coverage. The only thing is the setbacks. So right now, the unique shape of the property, which is one of the most classic variances in case law, is that a unique shape property, that can be a true hardship. And this is a unique shaped property on a unique street. And it does prevent here the reasonable use of the property, which is a house that's in line with the neighbors' houses. This is just showing the uniqueness of this property and how it starts at 107 feet in width at the bottom, which is a normal size depth, a normal depth of a lot, and tapers up to about 53 feet on the north. So most lots are not shaped like that. Most of them are rectangles, parallelograms if you want, but most are not shaped like this. The second criteria is that the circumstances are peculiar to the property at issue or to a small number of properties, that they constitute a market exception in the zoning district. I did put in other zoning. It's zoned RS8. I will say, again, MOLA is unique, but this is the criteria. RS8 properties, it's a typical neighborhood. You have between 100 and 135 foot depth. All of the properties are uniformly or mostly uniformly laid out. They're squares or rectangles. That's a typical. Even on the aisles, on some of the other aisles, they're square-shaped lots, 110-foot depth, really, reasonable to develop on. And again, our buildable property depth varies from about 3 feet to the north because of the required setbacks. You have 25-foot front, 25-foot rear, so you can only build 3 feet in the middle. Whereas if you have 110 feet, you've got 60 feet to develop, and you can actually make a house function at 60 feet. But ours, we have 3 feet in the middle to develop, about 20 feet in the 3 feet in the north, about 20 feet in the middle to develop, and going on to 57 feet in the south, where it becomes reasonable again. You can see our neighbors to the south, 107 foot deep, 120 feet deep, fairly uniform. Again, same across the street. It makes an architect's job a lot easier, and it makes what you would consider a normal house design. This is to the north. We're not only unique within the zoning district, we're unique within Mola Avenue in this zoning district. The third criteria is that literal application of the ULDR will deprive the applicant of a substantial property right that's enjoyed by others. Fort Lauderdale recently adopted I say recently, I use this in other hearings. It's been about 4 years since they adopted the property rights element. But it's a right of a property owner to use, maintain, develop, and improve his or her property for personal use of another person, subject to state law and local ordinances. Local ordinances is, of course, in there. The code is a local ordinance, which also does allow variances, especially if you meet the criteria. This is what could be built on the property within the setbacks. It's just not a normal house. Looking at the layout of it, it's weird. It doesn't fit within the neighborhood. It's not marketable by any means. Not that this one needs to be. It'll be homesteaded, and the person who's building it now is going to be living there. But it's not a reasonable house design. The fourth one, and the most important, is that the unique hardship is not self-created by the applicant, nor is it a result or mere disregard for ignorance of the ULDR. This property was platted, before the property owner was born. This was not designed. The layout of these lots was designed long ago, and is not the applicant's decision there. And it is a unique hardship. Building on an irregularly shaped lot, again, is one of the classic variance hardships in case law. And the last was discussed at length last hearing, and is it the minimum variance necessary for a reasonable use, harmony with intent of the ULDR and adjoining properties? And that's when we got in the discussion, can you go 1 inch? Can you go 6 inches more setback? Probably. But that's not what a reasonable use is. Again, you can build a tiny house here and meet the setbacks, but is that reasonable? And what we did is we used the adjoining properties and using the lot coverage maximums and floor area ratio maximums to determine what's reasonable. And we do believe that this is a reasonable use of the property that's frankly set back further than, I don't want to say most, but most or close to most properties on Mola. This one's going to be further back from the street. This is our neighboring property directly to the south. You can see they are built on the street.
Andrew, how much time are you going to need? How much more time?
15 seconds.
Go for it.
This is to the north, which many of you saw driving in. This one has a little more unique legal issues, but again, it's compatible with it. This one's built 1 or 2 feet from the street. And that is my, I'll end it there. Thank you, and available for any questions.
Thank you. I'm going to save you a little time for rebuttal. We have some.
Yes, please.
Yeah. Okay. If there's anybody from the audience that wish to speak, I'm opening up the public hearing. We do have some people who have registered, so I'm going to start with Rick Pleasance. If you could please reintroduce your name and your property address. And we have 3 minutes, so
okay.
Go right ahead, Rick.
A lot of stuff to respond to. We're at 422 Mola, which is right across the street from this property.
And if you could please restate your name because it's being
Yeah,
recorded.
Rick Pleasance.
Thank you.
I tried to jot down a lot of what the council said to respond to. One thing is that we do have a narrow street. I understand it's 12 feet, not 15 feet, which is, we all have been trying to coordinate with the neighbors to try to add 2 feet to both sides to help alleviate that, but we have a narrow street. We talked to zoning staff and have learned a lot since the original hearing, and talked to the city attorney. The 2 properties that they're trying to kind of represent as a precedent, which is the 2 that they show in the picture. I can represent that there are ourselves building a new house, as well as 6 other ones that are right next to us across the street that all conform completely to the zoning ordinance. So the 2 that he points out, there's a history to them that I think the board needs to understand and get an explanation from the city attorney and the zoning staff, because we just learned what that history is and it doesn't apply in this case. We have not seen anything with lot coverage or FAR, so the representation that's been addressed is kind of just a generalization that we'd like, and we're more open to participate in a discussion to further address that as a concern. The building envelope, I know at the original board hearing, one of the board members suggested that they look at a redesign on the house to potentially to work within the building envelope. Unfortunately, there's been no effort to do that, and I think that's viable. There's viability of looking at that, and we're trying to be sensitive neighbors, but unfortunately, there's a universal concern here that if anything built close to a narrow street is going to create some negative impact for all of us. The water, the stormwater drainage and all that is an issue, but I think that's a separate issue that the city is trying to address, along with a number of the neighbors that are all willing to participate in that. I think there are unique lots there, but there's a couple, we're really worried that this is going to be a precedent issue and needs to be looked at very closely. The actual depth of this property and so forth, I think there's a tendency to just kind of gloss over what is there and tend to represent it as exaggerate the limited footprint there. The footprint is got a lot more buildability than I think has been represented in the hearing. I'm just trying to follow my notes here. That's pretty much most of our concerns with the property. We really generally don't support the variance as it is. It has been represented, but we're still open for further discussion on what may be helpful to help correct the street issues. But that's essentially, hopefully, fits in with my 3 minutes. So
Thank you, Rick. Did pretty good. Next, we have Sir.
In the fact that the lot dimensions were very well known when somebody goes by this lot. So you know what you're getting when you are buying a lot that has a little bit of a weird design. And you are basically creating your own hardship when you do not take into account that there is a shape that will make difficult for you to build a house. The second thing I'd like to comment is that it's not the first time that the owner refers to 3 properties in the street that do not follow the setback. As Rick just mentioned, the 2 big white houses, I don't know if the board is aware, but the legal counsel for sure is. That's a completely different situation. Those properties, they own the other side of the street, and they had a legal case that went all the way to the Supreme Court that I followed very closely, that they questioned that setback should be counted from the other side of the street, basically from the water. And they did not consider the Mola as a street, but like, I think way of passage or something like that. That's what's created those variances there that allow the street to be done. What it's a terrible problem right now. You cannot cross two cars over there. They have curbs, and it's a very, very big hardship for the street, but it's water under the bridge. The third house that he also showed a little picture here that has the carport. That house was built, if I'm not mistaken, in 1923, way before any city code even existed. And that house, it's a big problem in the street for other reasons. For example, the whole discussion about raising the street to eliminate the flooding issues with the seawalls and things like that cannot be done because that house was built below the level of the street and floods constantly. One other thing that I'd like to comment about is there are clearly other architectural solutions that could be applied here. We're talking about a lot that has irregular design. You can build a house with irregular design. You can make a curved wall that will avoid, for example, some of that. Will cost more, absolutely.
If you could just finish your thoughts.
I have one more. Just to reinforce something Rick said about the precedent. There are no houses, with the exception of this 1923 and the two houses that had the issue with the canal, that are built outside of code. Everybody on that street has built that code. There is a house for sale right now that, by the way, a potential buyer had said, I'm waiting to see what happened with this request for variance, because before I put an offer to buy this house that will be teared down, I would like to see about the variance because I want to use much better this lot. So it's something to keep in mind on the decision you guys will be making.
Okay.
Thank you very much.
Thank you, sir. Next person to speak, Terry Cullen. And Terry, same thing, if you could please state your name when you get up there and your property address.
Thank you. I'm Terry Cullen. I live in, don't live, we're building a house across the street at 422, which you might say is one that would be impacted perhaps, but I think we've covered most of the points. The lot, in fact, has not changed the shape since it was purchased. The rules for setback have not changed since it was purchased. It was purchased with those things known. One thing about this diagram, I think, is fairly obvious. You can draw 9 cars in there, but if you want to move a car, you have to. If you want to move a car out of the garage, you have to move 6 cars to get it out. There's no room on the road or in front of the property to allow even for 1 car to be moved. If you put 1 car out there on the street is essentially totally blocked. If you put 5 cars out on the street, I think you can see the absurdity of this. I think the point is that everything that's being built now is being built, including the house that we're building. They're all obeying the setback 100%. And there is a house that could be designed, which is that would fit on this lot. That wasn't a requirement for somebody to buy the lot. You can buy the lot and not put a house on it, or you can choose to put a house on it that would conform to the setbacks, and that's the choice. It's not something that cropped up that created some kind of a hardship. So, thank you very much.
Thank you. There's a name that is kind of illegible. So if there's anybody else from the public that was wishing to speak. Okay, I did have one name, I just can't read, it's not real legible. Okay, so if that's it, if there's nobody else wishing to speak, let me bring it back to the board. Board, do you have any questions of the applicant? And Andrew, if you could come up. Board, your pleasure.
Can you just flip back to the picture, the rendering of the house itself?
Microphone.
And I do have some points to discuss as well.
Okay, I'll leave that after the board if you want, or do you want to speak about that?
No, I
Okay.
do not want to go out of order.
I'll give you your opportunity. It's up to
Yeah,
you.
I do not want to go out of order.
Okay, go ahead.
I just have one question. When you're moving the pool within a foot of the wall, is that going to be just grass area? It's going to wall? Is it a waterfall? What are you doing with that foot?
It's grass. I don't think that part has been designed yet, but probably grass, maybe concrete, depending on how it'll connect to the seawall.
Okay.
And also on pool setbacks are measured interestingly. No matter where your dock is, how far out it goes, they're always measured to the wet face of the seawall. So it might look like a foot. It might look like it's 15 feet away from the water, but it's actually 1.5 feet from the property line. So that's just a little diatribe about pools.
Okay, Andrew, you had said that.
Yeah, on the lot coverage and FAR issue, I just want to soothe some concerns there. We're not asking for variances to lot coverage or FAR. So if we need a variance from that, we're coming back to the board. So that should not, but we are meeting it. So while I made no conditions on the record today, which I'm happy to do, that we're going to meet lot coverage and FAR. If we don't, we're back in front of this board for a variance. So I can assure we will meet those. One of the commenters mentioned that there is a reasonable, and it's possible to do an irregular design on this lot, and they're not wrong. It is possible to do an irregular design. But the variance criteria is about reasonableness. And irregular is kind of the opposite of that. Again, just adding to the criteria. This will not set precedent because variances are not subject to precedent. This board takes it on a case-by-case basis. But I also want to show that we're the only lot on Mola that's shaped like this. The one across the street, yeah, they can definitely build within the setbacks. They have 110-foot depth at the smallest. That's 60 feet at the pinch point. That's 60 feet of depth to build a house. That's very reasonable. That's what I've been talking about this whole time. We could do an irregular design. We could do a small house, but that's not what the variance criteria is about. And then there was another mention about 5 cars out on the street. We're not designing this to fit 14 cars. The 9 cars, unless they're having a Super Bowl party, I highly doubt that all 9 cars are going to be there at the same time. This is one family living there. So we're not adding spots for more cars. That's not reasonable either. And I do like that one of the speakers mentioned that they are working to add 2 feet to both sides of Mola. We're on board with that. We're planning to do that on our side. Thank you.
Thank you. Actually, not yet. We're back to the board, but thank you. Board, any other questions of the applicant? If not, I'll entertain a motion. Okay, close the public hearing, and let's see what we do. I'm going to look over at you, Pat.
It's great to be so popular, I struggle with this one, to be honest with you. I really do. Because I think that at a previous meeting, or when it first came before us, it was deferred because one of the board members who isn't here tonight had said something about, can you redesign it or can you move it around a little bit or whatever. And it came back the same way. It's the same way as it was. Is it? Am I wrong?
Yes. We were asked to meet with the neighbors, which
Okay. No. All right.
yeah, and which we did. We had 19 calls to one neighbor who didn't show up tonight because he supports us. The neighbors across the street, we're building a lot on a vacant lot.
Sir,
Okay.
please.
All
Sir.
right. Okay.
Sir.
All right. Thank you.
We did
But
bring the phone call log.
Usually, I'm like, well, you can build a smaller house or whatever. But I looking at the application and looking at the criteria, and being very familiar with MOLA, having friends that live there, it is unique because the two properties that the one gentleman talked about do get that one White House is just, every time I drive by there, I'm shocked that it's there, but because there's no setback. But they had the unique situation there where they own both sides of the street. And so they're treating that as an easement. They're treating you as a street. And it is treating you differently. And it is a very uniquely shaped lot. Because it's the only one like that on MOLA, I do think you meet the criteria for a unique property and the hardship. So I will make a motion to grant. Now, how, Dwayne, should I break them down? I'm gonna make a motion to do them all. So, or would the board prefer I do one by one? Whatever.
Let's do one by one.
One by one? Okay. My reasoning is the same on each one. So I make a motion to grant the variance from 47-5.3 run table of dimensional requirements for the RS8 district to allow the 15-foot front yard setback for the garage specifically. Correct? That's the only portion of the building that requires the 15-foot setback is the garage.
There's the second floor overhang, which you can
And the
see.
second floor overhang.
Yeah, that's it's
shown
only
on
at the
plans.
corner, the extreme corner
Okay,
pinch point.
shown on the plans, and to grant a variance to allow the 15-foot 8-inch rear yard setback where the code requires 25 foot.
Thank you. Do we have a second?
Second.
Okay. And further discussion? Doug?
Yeah, can we just do a modified to restrict the garage to a single story? So they can't make it a two-story?
Oh, to build out the house more on top of the garage or something?
Yeah. To say, but the 15-foot setback
To have a
is for a
15-foot
single-story
setback
garage.
for the garage, a single-story garage with no residential component.
We'll proffer that to keep
Okay,
it easy.
thank you.
Okay. Any other discussion? Nicole, let's take a vote on that.
Mr. Shetman,
Yes.
Mr. Galis,
Yes.
Mrs. Williams,
No.
Mrs. Rathburn,
Yes.
Mr. Mead,
Yes.
Chair Elfman.
Yes. First one passes. Do you want to make a motion on the second one, Pat?
Sure. For the same, based on the same criteria, I make a motion to grant the variance from 47-19.2 P freestanding shade structures to allow a freestanding. Actually, that could be smaller.
It's the setback that we're requesting the distance from. So we took it and we shifted everything back.
All right. To grant the variance for the freestanding straight, whatever, to 2 foot the rear yard setback where the code requires 10.
Thank you. Do we have a second?
Second.
Okay. Thank you, Jay. Any discussion? Nicole?
Just one moment. Mr. Shetman,
Yes.
Mr. Galis,
Yes.
Mrs. Williams,
Yes.
Mrs. Rathburn,
Yes.
Mr. Mead,
No.
Chair Elfman.
Yes.
Motion passes.
Okay, and the final one, swimming pool, 47-19.2 BB, swimming pools. Motion to grant the request for variance to allow the swimming pool with spa to be constructed at a rear yard setback of 1 to 3, whereas the code requires it to be minimum 5 feet. For the same reasons.
Okay. Do I have a second?
Second.
Okay. Motion second. Any discussion? Okay. Nicole, you're up again.
Mr. Shetman,
Yes.
Mr. Galis,
Yes.
Mrs. Williams,
Yes.
Mrs. Rathburn,
Yes.
Mr. Mead, Chair Elfman.
Yes.
Motion passes.
Motion passes. Nicole, before we go, you did get the proffer from Mr. Shine on the first one, 47.
Correct, I
dash five.
did, and I re-listened to the tape
Okay.
to
Thank
make
you.
sure that it's notated.
Okay.
Thank you
Andrew.
all.
Okay. Before we take the next case, I would like to take a 5-minute break if we could. So let's do 5 minutes and then we're going to come back in. Okay, we're going to get started. Next case, case number 24110001, 2950 Southwest 17th Place. We're going to start with disclosures. Jay?
No disclosures.
Doug?
Sorry, which one is this?
This is case number 2, or agenda item number 2.
This one?
Yes, looking for disclosures. In the microphone.
I spoke to Bert about this.
Okay. Daniela?
No.
Okay. Jared?
No disclosure.
Pat?
No.
Okay, and I did a site visit. Also, we have letters and emails that were sent to us and also part of our package. And we have our applicant. How much time do you think you need for your presentation? 15 minutes. Okay.
So, Chair, if
Yes, if you want to start, Dwayne. Sorry, thank you.
sure, not a problem. So if I
Thank you.
can give a little background prior to the applicant speaking on this matter. This matter was before the Board of Adjustment previously and was denied. The variance was denied. The applicants appealed it to the Circuit Court via writ of certiorari. A final order granted their petition of writ of certiorari, and I just want to read into the record for the, I know I sent a copy of that, or staff did, earlier this week to the board members, but I think it's important, and I'm going to leave the case citations out, but I'll just read a portion of the order into the record for the benefit of the board members and the benefit of the members of the public as they approach this item. So the judge writes in his order that Section 47-2412A4 of the ULDR outlines the requirements for obtaining a variance, including specific criteria for exceptions and interpretations of the Unified Land Development Regulations. Under subsection A4, an applicant must demonstrate by preponderance of the evidence the existence of a unique hardship attributable to the land. This burden includes addressing each of the 5 required components. Only upon satisfying these threshold criteria, the board may consider the variance request. The record, and he's speaking about the record of the hearing, indicates that a unique hardship exists. The property lacks access to a public road, rendering it unbuildable and effectively depriving petitioner of any reasonable use of land. Accordingly, the court finds that a unique hardship exists as required under the ULDR. The record also demonstrates that the board relied solely on lay witness testimony expressing concerns regarding the potential future flooding, a diminution in property value, and concerns about setback regulations. Lay witness testimony may constitute competent substantial evidence if it describes observable, objective conditions rather than speculation upon potential unfavorable impacts. The witnesses' objections to the variance cited no factual observations and were merely based on fears of potential harmful impacts to the community. As such, these fears do not constitute competent substantial evidence. Other than the speculative lay witness testimony, there is no other specific or objective evidence available in the record supporting the board's denial of the variance request, nor the proposed use does not satisfy the antecedent requirements as outlined in Section 472412A4 of the ULDR. Accordingly, there is no competent substantial evidence to support the board's denial. As one form of relief, petitioner requests the court order the board to grant the petitioner's variance application. This court does not have the power to direct a town to a particular course of action. Therefore, the court cannot direct the board to act in any way. This type of relief is denied. Having carefully considered the petition, its appendix, responses, and applicable law, the petition for writ of certiorari is granted, and the final order dated January 8th, 2025 is hereby quashed. What that means, the legal effect of the order being quashed means that this matter is returned to the lower tribunal, which is this Board of Adjustment, as if that order was never put in place. The case remains pending before the Board of Adjustment, and the parties are restored to the procedural posture that they had prior to that order that was quashed being made. What that means is that the testimony and evidence presented at the prior hearing is admissible and could be considered by the board members. What I would like to advise council is that the composition of the board has changed, and the new members of the board do not have the benefit of the prior hearing, and so the evidence that they're considering, again, the minutes of that meeting, I do not take to be evidence of the proceedings based on which you can make your factual determination upon. So with that said, you're treating this case as a fresh case, basically, and making your determination. And I just wanted you to be aware of the findings of the court and overturning the prior decision of the board.
Mr. Spence, I'd like to make one point of clarification, if I may.
Sure.
The record still consists of the prior hearings, meetings on, I believe it was December 11th, 2024, and January 8th, 2025, correct?
That is correct.
And also, of course, the record also includes the decision by the circuit court.
No. So I just read into the record the decision of the circuit court. In terms of it being evidence in this proceedings, I do not view it as such, but I think it was helpful for the board to understand the court's reasoning in quashing the order.
Thank you.
Chair
okay.
Altman?
Yes.
Can I just want to say before we start that I think I was one of 3 or possibly 4 board members that was at the original hearing, and can state unequivocally that I did not rely on lay testimony from anyone regarding flooding. Flooding didn't interest me. What I relied on was the applicant's testimony, which was not lay testimony. It was specifically from the applicant with respect to their lack of due diligence, lack of survey, lack of title insurance. And I think that was very specifically stated in the record. So I would have to disagree with the findings of the court on that issue, and just wanted to go on the record with that.
Okay, Pat. Okay, sir, if you're set.
Thank you. My name is David Isaacson on behalf of the applicant, H&M Land and Housing and Land Development, LLC. Here on their request for a variance. As Mr. Spence mentioned, we met here a year ago. The issue is that the applicant bought a property after performing due diligence. I know Ms. Rathburn has a question about that, but the applicant asked the seller's agent, their own agent, their title company, in fact, went to the city several times and asked, is this land buildable? And every single one of them said yes. Later, after buying the property, they learned that it was landlocked and unbuildable. This was after they had gone to all of these people. They went to get permits, and the city then said, wait a minute, this land, we're looking at the GIS model, this land, and that's the GIS model, and you can see in the red, the land looks landlocked. So this is the URDL that talks about landlock, this 47245D3G. Says that every lot shall abut upon and have permanent access to a public street. That's a hardship. They can't do anything with the property. They can't build on it. They can't do anything. That's a unique hardship. The circuit court found that based on the evidence that was presented in the last hearing. So what the applicant did to try and overcome that hardship was to buy or purchase a piece of property. And it made the property then look like this the red property. And you'll note that there's two long horizontal lines. Those are the lines at issue here. And those lines, the city's saying, do not comport with the ULDR requirement under 47245D3E that says side lot lines shall be at substantially right angles. The order of radial doesn't matter. Should be at substantially right angles to street lines. It's hard to understand that, though, because you can see that those parallel lines are substantially perpendicular to the street right next to them. So it's hard to understand exactly, in some respects, why we're even here. But the city said you need a variance, so we're here asking for a variance. The history was we had meetings last year in January and December. The board rendered its decision in January of 2025. The applicant disagreed. Moved for certiorari, petition for certiorari, and that was granted in August 13th of 2025. And it's important what the court said, and Mr. Spence touched on it, but I'd like to emphasize it. Importantly, what an applicant must do is demonstrate that the existence of a unique hardship attributable to the land. The burden includes addressing each of the 5 components. In the last session, we saw there were 5 components for a variance under the ULDR, and I'll go through them briefly just for the benefit of the new board members. In this case, this is the holding. This is what the circuit court found. The record indicates a unique hardship exists. The property lacks access to a public road, rendering it unbuildable and effectively depriving the petitioner of any reasonable use of the land. As such, the court found a unique hardship exists as required under the ULDR. Therefore, the court said the applicant is entitled to a variance. The court just wasn't allowed under the rules to actually order the board to grant that variance. Now, I could stop there. For the benefit of the new board members, I would like to go through real quick the 5 criteria. And this is them listed here. We heard them in the last session as well. The special conditions. Well, the property's landlocked. Okay, under the code now, the city will not allow it to be built on. It has no practical use or value. So there is no reasonable use of the property at this point. These circumstances, landlocked, are peculiar to this particular property. Yeah, to this property. Yes, this is unique. There aren't a lot of landlocked properties in Fort Lauderdale. So most are developed, but the next one, the third one, is that literal application of the provisions of URDL would deprive the applicant of a substantial property right. That is true in this case too, as the circuit court found. The application of ULDR just deprives the applicant of developing its land. Most other properties in Fort Lauderdale can be developed. That's a substantial property right that the applicant doesn't have. Also, there are other flag lots, or these kinds of lots that would also violate that section of the URDL that we're seeking the variance from. Here's some examples. The one on the far left is a typical flag. The one in the middle is exactly the same kind of thing we're asking for, which I think is kind of, you could call it a double flag. There's a flag on the top and the bottom. This one is another traditional type flag, the one on the right. These are, I don't know what you call them, but these are properties in Fort Lauderdale that clearly have side lot lines that do not conform to the requirements of the ULDR. The fourth one is that the unique hardship is not self-created. It's clearly not self-created, and there's good Florida case law on this. The applicant had nothing to do with creating the hardship. The applicant bought the land; it was landlocked. I want to quote a case. I want to quote from a case, and it was actually in the last section too. But the quote is from the City of Coral Gables v. Geary, which is 383 Southern 2nd 1127. And the quote is, "Since it is not the act of the purchaser which brings the hardship into being, it is incorrect to charge him with having created it." In this case, that applies exactly. The applicant did not enact in any way to bring about the landlocked condition of the property. It is absolutely improper, not even just unfair, but it is improper to say that the applicant created it. That's Florida case law. The variance is the minimum variance, and there's a whole bunch of reasons. The flag is required to abut a public road. Without it, there is no abutting a public road. That's the second. It will be unusable. It can't be reasonably used for the purpose for which it's zoned. That's an important point also. It's zoned as residential, R6.85, or I think that's 6.85B, I think it is. That's for single-family homes. It's exactly what the applicant wants to put there, single-family homes. It conforms with the nature of the surrounding area, all single-family homes, and it will not cause any additional traffic or whatnot. You're talking 2 homes, and this is just going to be an access way, a small driveway. That's it. The LDR aims to promote orderly development and ensure public safety. This will conform to that because it allows structured development, so to speak. As I mentioned, it won't be incompatible with the surrounding neighborhood, and it's the ingress and egress won't be a problem. It's just a small driveway. This just explains how the board can make the variance when it sees fit. This is getting back to that idea that the side lot lines really are really at right angles to a street. If the board wants to discuss that, we can discuss that further as well, in the interpretation aspect. And that is it. So if anybody has any questions, I'd be happy to field them. If you'd like to open up the public discourse first, we can go that way.
Okay, that's exactly what I'm going to do. Thank you. And we'll save you some time for rebuttal. First person I have is Michael Pileggi. If I mispronounce your name, I apologize. But when you come up here, if you could please state your name properly and your property address. And you'll have 3 minutes, Michael.
Thank you. My name is Michael Pileggi. I live in 1818 Southwest 30th Terrace. My wife and I, we owned the piece of land that we sold to Hani Levy and Michael Gill of H&M. And the reason for that was because we found about their hardship. And we obviously felt for them, and we saw the need, and we stepped in, and we're grateful for them and their friendship that we've developed out of that. The reason why I'm here to testify is because throughout the time that I've gotten to know them, I have had a close encounter to all of the hardship that they have endured, starting from how they bought the land to how they surveyed the land, how they paid for a survey on time, how they did their due diligence on time, how they had title, insurance, and everything on time, and how they did everything. And when I came here on the first meeting that we had, I remember listening to Ms. Rathburn, and again, stating it again to Ms. Rathburn, I would like to just specifically address you and just ask you to consider the actual evidence. I understand that it is a complicated case and that dates can get a little finicky, but ultimately, what the evidence shows, based on all of her actions, is that she did everything at pace. I saw it myself, and you have access. You had it on the original package, and I appreciate you doing that. And the board, I ask all of you guys as well. The evidence is there; it's laid out for you. Please, instead of weighing in on any irrelevant comments that may come later on, the fact is, you stated it. You felt that there was no due diligence. There was due diligence. You just have to look at the data, look at the dates, and then just move on from there. But that's all I have to say. Thank you so much for your time.
Thank you. I have, and if I mispronounce, I apologize, Mariatri Menendez. Anyone up there, if you could please just restate your name and property address.
Photos of what some of the trash that's currently on the land.
We're getting a lot of exhibits here.
So for clarification, for
Yes.
the photographs that the applicant is passing out
Yes.
are related to the
Oh yes,
are your exhibits?
it's trash that's been dumped on the same property that's in.
No, I'm asking, the applicant is passing out exhibits. Are they related to your testimony?
Yeah.
Okay, thank you.
So, my name is Mariatne Menendez. I live in 1818. I'm here because I feel like this whole thing has been unfair. I mean, last January, we were here. A lot of comments were made that were untrue, and Ms. Rathburn just made an untrue statement at the beginning saying that they didn't get title insurance or any of that. It's in the record. It was there January. It's still there. It hasn't changed. I also noticed how the 2 prior cases were granted, and honestly, like, it was based on financial hardship, which I looked it up, and it says, and the code says that that's not a reason for granting a variance, and also preference. This hardship was not caused by them. It's something essentially that they bought into, that they had no idea. They tried to do their due diligence. They came to the city first. Before they even did the flag lot, and we sold them the land, we talked about maybe giving them an easement through necessity. And the city was the one that said that, no, that's not allowed. Why don't you just purchase it instead? And that meeting, I'll tell you because I have the date here. Sorry. It was May 3rd of 2024 at 2 p.m. when she came to meet with you guys. And then we've just kind of like we're going around for, from place to place, and you guys keep directing her to do stuff. She goes and does it, and then we're back to square one. Honestly, I feel like most of this issue has been caused by you guys. Right now, the place is a dump. It really is. I have found dead animals. I've been cleaning up for like the past year. As you guys can see, the neighbors, the same neighbors that were complaining, they throw trash, and those are screenshots. They're dated. You can see it happens continually. I've been trying to stay away from like making complaints, making reports to try to keep the peace, and this led me to have a restraining order with the next door neighbors because of their harassment and because of their threats, just because I stood up and said, like, this isn't right. A lot of the emails that were sent, a lot of the information dates are 100% false. And honestly, if this goes to court, they should be held in contempt and for lying, because a lot of it is just not true. And honestly, like right now, it's just a dump, and it's up to you guys to make the right choice.
Thank you. Martin Kessler. And Martin, if you could please just restate your name when you're up there and your property address.
Okay. Hi, my name is Martin Kessler, and I live at 1790 Southwest 30th Terrace. I'd like to give you guys something to look at so you can kind of get a better framework of how I feel like I'm being most affected by this. So kind of.
Do you have a copy for everybody?
Yes.
Okay.
I really, I'm submitting this letter as a concerned resident directly impacted by the proposed development. My property is uniquely affected by the proposed construction and would encircle my home on all 4 sides, effectively isolating me. I feel deeply concerned about several issues. There's traffic issues with increased roads around my house. when I bought my place, I didn't think I'd have 4 roads around my house. I could have never imagined somebody trying to pull something like this, you know. And, you know, I feel like, you know, they say they didn't have a heart, you know, they say the hardship wasn't brought on, they didn't bring it on upon themselves, but if you'd had the proper title insurance, you would have figured out this property was landlocked. So they can't really say that. That's just not right. It's just not true. The island effect would create by this property will result in my home being encircled by roads, which are likely to diminish my property's market value. And if you look at the diagrams, you can kind of get some kind of an idea what I'm talking about. Yeah, this deeply upsets me, you know. I know how they feel, you know, they bought a piece of property, they've had to go through all this, you know. But, you know, I've got 2 clips on the back of here. The top one, the clip shows this is from the Broward County website, shows my property highlighted in red. It shows the proposed road that would go just cut right down the middle of our homes. And you can see the flag-shaped lot that they've created. And they did create that. The bottom one shows basically where the road would, the orange road is what's already in place in Southwest 30th Terrace out in front of my house. To the north is 17th Place, which is a private road with no right-of-way access. The yellow road is their proposed road, which would cut right down the south side of my house and then going right behind my house. I don't agree with that, you know. I mean, this road's going to be about 15 feet from my bedroom window. And, you know, I you have to excuse me, I'm not a very good public speaker, but...
That's right. If you could just finish your thoughts, because we're out of time.
Okay. All right. Well, I thank you for the time. Thanks.
Thank you. Next, and I'm sorry I can't read the last name, Raul. It's Al, first name. I'm going to try the last name since nobody stood. Sasam Mend? Going to pass? Okay. Thank you. Henry Avoner. Okay. Did I do okay with the name? Close enough. Okay. Alvarez, I'm sorry. And I will have you restate your name and the microphone when you're up here.
Good evening, everyone. My name is Henry Alvarez. I was here before. I understand what's going on, especially now that we're talking about hardship. It was what was brought up today, apparently in the case before, and the current case. I've lived in that neighborhood since '77. The house that I currently live on is one of the houses that is right behind the lots that they have currently. So I'm very familiar with that. I've probably lived there longer than anybody that's lived there. I've lived there since '91, before Hurricane Andrew was around, came through that neighborhood. So I'm very familiar. I've known everybody that's lived in that neighborhood that's owned houses surrounding that lot. That was known even to me and to anybody who's tried to buy that lot, which many people tried to, was very known, very, very well known, that was landlocked and no access. I know they say they did the due diligence, but apparently they didn't ask anybody else in that neighborhood, why did anybody ever else buy that lot? The owners that had it, they rented it out to people. People used it for other things because they've known that lot was landlocked. It comes back to the same thing, due diligence. If they would have asked somebody, they could have come to me, that I've been there forever, and I lived across the street, that was a landlocked lot, and no, people tried. I promise you, I know that people tried to buy that and could not do it because of that issue. So that is one of the main issues that's going on here. All the other stuff about, being a little driveway where one car can go in and one car can't. Can fire trucks and a car come in and out of there? Probably not, because you're literally, he's going to have a hardship. He's going to have 4 roads around him with cars going in and out, Yeah, they have a hardship too, but they're also going after the people that sold them the property. They got a legal case against them. So they're still suing those people, whether it was the owner of the property when she sold it, when her husband passed away, and the people, the attorneys they had hired previously, they still got litigation going on. If you guys can wait to see what the litigation is, maybe it gets resolved that way. They get all their money back that they lost, and everybody goes on their way, and the property stays there. In reference to being a dump, I live right behind there. It's not a dump. It's a dump because they've gone in there and dumped tons of rock on the property. They go in there with the machinery, clean it all up, spread it around, knock trees. They go on to 17th Street, create a hardship because they ruined the road there. They cause mudding and all that to dump their stuff that they're doing into a private Florida FP&L lot. So there's hardships for a lot of people who live there, not just them. Unfortunately, if they would have asked the right people, they would have got the right answer that that property was not buildable and landlocked. Okay, we're back at this again. Thank you and have a nice evening, everyone.
Thank you. Okay, Jesse Alvarez. And when you're up here, Jesse, if you could please restate your name and the microphone and property address.
My name is Jesse Alvarez. My address is 2921 Gertrudis Place, Fort Lauderdale, Florida. I live directly to the south of the lot in question. And I'll start with, I think the board needs to consider how we got to where we are today. And Henry touched on this a little bit. I believe the petitioners, I believe they did due diligence, but inadequate due diligence doesn't qualify as due diligence. If you're going to do due diligence, it needs to be adequate. You just can't simply do a little bit of due diligence and not follow up on concerns that may have been raised during the course of that due diligence. If you're getting inadequate responses to your questions and people aren't calling you back, you shouldn't rush to make a decision until you're sure you've done quality and adequate due diligence. But all that aside, the petitioners may have actually been defrauded. In looking at the ad for the sale of the property, it did make statements that there was access. So I believe they could have a good case, and they do have a good case because I believe they were defrauded by the seller. And I think today's ruling, maybe it would be in the best interest of the board to make a rational decision. Finally, somebody could do something that's well thought out. Ruling on today's petition should be deferred until litigation settles. The ongoing litigation could possibly mitigate the need for this petition. As for the petition, I believe it's a flawed solution to an awful scenario. Further, the petition appears to possibly be misleading the board. If the petitioner is only building one home, the driveway could simply just go straight into the property. There's no need for it to turn left and head north to then turn right. The purpose of turning left, and like you're going to turn right into the driveway, and then you're going to make a left behind that gentleman's home, and then you're going to make a right that runs parallel to Southwest 17th Place and head east. The purpose for that is to then continue on and have access to the other part of the parcel that they also own. So they purchased a big piece of property, and now they've divided it into two parcels. So there's a parcel right to the east of the property that's depicted in the diagram. And my belief is that they're going to build another home back there. When they originally purchased the property, I think their wishes were to build 3 homes. There was a lot of press in the newspaper. They complained to everybody. They were on TV. And I think somewhere in there, I could be recalling incorrectly, but I believe somewhere in there, their goal was to build 3 homes
They had to redesign everything, so maybe they're going to try to build 2 homes. I don't know if that's something that's important to you.
If I could just have you finish your sentence.
Yes. If you visit the site, you could clearly see that there's potentially a better solution. Maybe the city can consider, or the petitioners can consider purchasing Southwest 17th Place. That would make the most sense. If they owned Southwest 17th Place, or if the city owned that, that would give them access to their property, and then they could build homes that look like they belong in their neighborhood. What they're building now doesn't look consistent with what's in their neighborhood, the way it's designed. Thank you very much. Appreciate your time.
Thank you. Is there anybody else from the public wishing to speak? Do you want to come back up? Okay. And you'll have time for rebuttal. By the way, just to make sure, did I already ask for disclosures on this when we started right in? Yes. I did? Okay, thank you. Just want to make sure I didn't skip.
Hi.
Hi.
Sal Semendi. We live on 17th Place, 2971 Southwest 17th Place. We're the second house in from 30th Terrace. I just heard the comment about using 17th Place. I wasn't planning to come up because that's been that's a private property that was deeded to each of the homeowners on 17th Place, and it is a narrow road, certainly not a two-way. We purchased our home with the intention of the quiet, peaceful little niche that created, and as far as I know, it wouldn't even be legal to do what was just presented as far as making 17th Place something that the city would take from us. It is deeded privately to each of the homes there. So I just wanted to come up and make that statement regarding the street. We also are very concerned about the address of this property, proposed home building, that for safety reasons and paramedics and stuff like that, it contains an improper address. That lot it was part of 30th Terrace originally. The neighbors here, that was their back property before they ever moved in, and it was parceled out. 17th Place is not on their plat. They're on a different plat altogether. So the actual address there needs to be changed. That's incorrect. If we can build, right now there's a fence they put up, and we feel like we're in a state penitentiary now. It's this huge fence just going around, chain link, in front of our house. And they have an entry in front of our house, which they've come down it many times to get into their property. Now they have another way to get in, which is fine. If whatever happens, that's, I can't, and that's up to you to decide that. But we plan to put a hedge in along our street to beautify it and to block off this construction. And if a paramedic or anybody came down the street and had that address, they wouldn't be able to get to that property. And so I don't know if this is part of what we're meeting for, but as soon as I heard 17th Place, make it public, no. So I just want to share those thoughts on that.
Thank you.
Okay.
Is there any final people from the public wishing to speak? Seeing none, I'm going to give you 5 minutes of rebuttal.
All right. I want to call Hanny up just for a minute to put an end to this idea that there was no title insurance. There absolutely was. I'd like Hanny just to testify to that.
Yeah, I want to testify for the lawsuits that been discussed. My lawsuits that has been discussed here have nothing to do to this case. Everybody that hold the information about this land that have no ingress and egress should be held accountable. If it's the seller, if it's my attorney, if it's whoever realtor that represent all these facts, they need to stand in front of a judge and in front of a jury and answer to those why that wasn't disclosed, why that wasn't told, that you got paid for this, and that's what you need to do. Then I occur damages that have nothing to do to this, what they talking about. Another thing, I had title insurance, I have attorney, I had I rely on all these people, and that's what I would like to say. Another thing I want to say, let me just finish. Okay. It's almost a year since we've been here, okay? The land is unusable. A property I cannot walk on this land, I cannot access to it, I cannot maintain it legally. Every time I'm in this street, I'm trespassing. This is absolutely demolish my small business. Me as a human being, me as a mother, took a toll of my family and my kid all this year. A lot of unsleepless night. This board still have the authority and the responsibility to resolve this very hardship. A Florida law recognized that the landlocked property is not a minor inconvenience. It's a total deprivation of use. No one buy land expecting to be forbidden of rich. Yet, dispute this reality. The board chose not to grant me release last year. Over the past year, I have watched a lot of board meetings, a lot of variants. I give you a lot of example on your guys' table. Case PLN BOA 24-100-05. Front setback, rear setback, architectural project beyond code limits. August 9, 2023. Case number PLN BOA 23-0600-01. A variance asking for setback by 2.97 feet. The builder admitted under oath that the hardship was caused by his own survey, a self-created error. Variance approved. Same hearing. Ground sign variance approved. Request for 91 square feet sign, only 24 square feet allowed. November 12, 2025, case PLN BOA 25.
May I take a quick recess, please? Just for, I have a minute 20 left. May I take a quick recess?
How long you figure?
Just a minute. Not even that. I just want to talk to my client.
Oh, no. Okay.
Counsel, can I ask you to kind of clarify in terms of the case that your client mentioned is not germane to this proceeding? She's not referring to the case at which this item was quashed?
No. So there's another case. There's a civil litigation going on between her and others.
That's all I need for the record.
The neighbors have referenced it. It's irrelevant to this case. Whatever happens here is not relevant to what happens there. It's not part of the 5 criteria.
Thank you for the
number one.
clarification.
Number two, the litigants in that case will deal with whatever happens. They'll know what happens in this case, and they'll deal with it, whatever that means, whether it means anything. Just to briefly go over some of the neighbors' comments. There was a comment about a penitentiary. Fences surround the people in the penitentiary. He was talking about fences surrounding another property. That's not a penitentiary. They talked about something about buying 17th Place. We went to all the neighbors on 17th Place and asked them, offered them money for a variance. They all said no. Not a variance, an easement. They all said no. Mr. Kessler talks about his land being surrounded by roads. It wouldn't be. That's absolutely just not true. He fails to mention that already in front of his house is a driveway. This would be just a driveway next to that, but it's just to service a couple of homes. There's not going to be traffic on that of any substantial, of any substance. Mr. Kessler also at the last hearing in December, he said he didn't want this because he's like, I can't remember if it was him or somebody related to him, but they said on that property they hide code violations in their backyard and they don't want anybody to look at them, see them, and say anything about them. So that's not a real reason. The due diligence issue.
If you could just finish your thoughts on this, please.
Yes, absolutely. So the due diligence issue goes to knowledge. And as I mentioned before, under the case of Carl Gables v. Geary, knowledge is not the issue. That applicant had knowledge. The court said that because the applicant had nothing, or because the owner of that property had nothing to do with bringing about the condition. In that case, it was a regular property. In this case, it's a landlocked. Because they had nothing to do with bringing about that condition, it was improper to say that they had created it. And with that, I can stop.
Thank you. And we're going to see if there's any questions from the board. So, board, is there any questions of the applicant?
I do.
Okay, Pat.
I've been sort of accused of either lying or being stupid. But if you go back to the original application for this, and unfortunately, it's not in front of the board, the original application is, and I might consider moving for a deferral till we could get the original package. But in the original package, the applicant said that she said at that point she didn't have title insurance. Maybe she got title insurance. I don't know. But asking the attorney, have you seen the title insurance?
I have not.
You have not. Okay.
But that's not relevant.
Wait. Let me.
That doesn't mean it doesn't exist because.
Okay. If it exists, the other thing that she said she didn't do, and it's in her application, in her own words, in her application.
Can you cite a page number for these?
Clearly, it's not in front of me, and so
it is actually in the it's in the papers. The application, the original application.
The original application is not in my backup.
It's in the package. It's in the support package.
It's not my support package. It's clearly. It's not.
I printed it out.
Let me just put it this way.
Let's let her ask the question.
She said that she didn't get a survey because she didn't want to go to the expense. Is that correct?
No. What she said.
She didn't get a survey.
No. She did get a survey actually on September 26th.
After she closed.
No, before. 3 days before.
If she got title insurance and if she got a survey, does her title insurance make an exception for matters of survey? Because typically, if it does, it would have an exception.
From what you just said.
It would have an exception for no access to.
It doesn't have an exception. What it said
if
was
it
it's
doesn't
not
have an
talking about
exception,
it.
then her title insurance would cover the fact that it's landlocked.
No, it doesn't. It doesn't. It was excluded.
It was excluded. Okay, so she knew at the time that her title company that she's claiming that she asked her title company, could she build, let me finish. She's telling us that she asked this title company if this is a buildable lot. I've been doing this 40 years. I've never had anybody ask me if it was a buildable lot, and if they did, I would tell them I didn't know, get a survey.
Let me ask you a question if I may.
Let me finish. So if she has a title insurance policy and it excludes access to a public road, then the title company either made a mistake or they didn't have a survey because the survey would have shown there was no access.
They actually had a survey on September 26th. And
if I may interject,
Go ahead,
so I understand the point that Member Rathburn is making, and that testimony was elicited based on the package. The court, in reviewing the writ of certiorari, did have the record in front of them, and although they did not put that information in their order when they found the hardship that it wasn't self-created, some of the pleadings made by the petitioner did include that information, and they stated in those pleadings that the record was devoid of evidence that addressed that, and the court appeared to agree with them. And I do appreciate the member clarifying the record and in terms of what the board based their decision upon. But as it stands, the proceedings today doesn't seem to be that far different in terms of the testimony and evidence that's presented to the board as the one that the court reviewed in making their determination.
I agree with that, except that it's been pointed out that I have said that she didn't have a title insurance and she didn't have a survey. her application, her original application said she didn't have survey and she didn't have title insurance. Now, if
it's a
that's
timing
incorrect,
issue.
if that's incorrect, then her application was incorrect. And you're telling me on the record, under oath, that she had title insurance and she had a survey, and that her title insurance does not cover the fact that it's a landlocked parcel, which would mean that there's an exception for the survey in her title policy.
I would ask that we actually look at that the language in there was exclusive, was an exclusionary language. I just can't remember exactly how it read. But it did not say that they guaranteed against that or something like that. It said they didn't cover it, or so. I can't remember exactly how it said it. I wish I had it with me, but I don't.
Yeah, I do too.
I apologize.
I'm gonna make a motion that we defer this till next month so that they can bring back that additional record.
I would object to that. We need to get this resolved.
Okay, so I wasn't here for the first round of hearing, obviously, but I'm confused as to why it matters whether she has title, whether she had title insurance or not. At the end of the day, this is about a property that is landlocked and whether that's a hardship and whether they have sought the minimal variance to alleviate that hardship. We just gave a variance to someone who just didn't like the look of the house that would need it to be built upon the land. So this one, the owner can't even access. So I don't know how we got here, and I haven't heard anything different tonight than I would believe the court already looked into. So why would we defer this any longer than how it's already been? Thank you.
Okay, if I may.
Go ahead, Doug.
If I'm not mistaken, this property was previously part of the property to the east, 1769, and they cut it off and sold it. So when it was part of that, it was completely legal and part of a street. So they took off a piece, so they actually made this, and they are
I'm sorry, who is they?
this property to the right, whoever originally owned it.
Okay, thank you.
Okay, so for the same token, if they cut off a piece that was 75 by 75 and sold it, and that's not big enough to build a house on, that's not a hardship. You bought a piece of land that you can't build a house on. So it's not really a hardship when you buy a landlocked thing that was caused by the predecessor. So maybe they didn't cause it, but they bought something that was not buildable.
It's the predecessor of H&M. They didn't do anything.
Right, but it says predecessor.
For guidance and clarification of the
H&M
record,
doesn't have a predecessor.
the court has already deemed that there is a hardship. The question that our board has been wrestling with and that the previous hearing tried to fetter out is whether or not it was a self-created hardship.
And I will wrap up and say, I mean, if you look at the land and walk it, there is no road. I mean, it's not like a hidden issue. That's what you bought. So it's like if you buy a house without a garage, you don't have a garage. I mean, you knew what you bought when you bought it.
So what else is to be done with this land?
Again, that's not the law in Florida. I keep repeating this case, Coral Gables v. Geary. And I'll read the section again.
That's okay. I don't think we're going to need to read that again. I think we've heard it 2 or 3 times.
Correct.
Okay. Thank you, Jay.
Procedurally, there's still a motion for deferral. Are you discussing that, or are you waiting for a second, or?
Well, we weren't discussing that, nor was I waiting for a second, but since you mentioned it, I will wait for a second on that one.
I guess I have a question on that for whoever made the motion.
So right now, give me 1 second.
Okay.
Is there a second? Okay, we die for lack of a second. Okay, go ahead, Jay.
My question on that would just be like, if we're determining if there's a hardship or not that's created by the applicant, like they didn't create this property. They bought it as it is. Them doing the proper diligence or not, like how would that have any bearing on the actual us deciding if they created the hardship or not?
kind of, I guess that's a question for Pat, who originally made that motion. Because
It probably doesn't, but I think my motion was based on the fact that several people got up and said that I had lied about what was said in the original application, and I didn't appreciate that. So in order to determine whether or not my reputation was intact, I thought a deferral would be appropriate. Actually, I think didn't this come back a second time? Because I think at the first hearing we asked them why they couldn't have access to the easement, and nobody had a good answer for that. And then they came back and they showed us the easement and how they didn't have access to it. And I actually think I voted for the variance. It was denied, but I think I actually did vote for it. Because my concern originally was that there was an easement for access, and it would have been very unusual for these people, this lot, to not have access to the easement. And when you brought it back and showed us that it wasn't, and I think, Dwayne, you'll remember that, at that point it was like, all right, you're not part of the easement. You don't have any way out except across the thing. And I actually think I did vote in favor of it. So, is this self-created? In my opinion, yes. But is that relevant? No. So I think if we're open to a motion, somebody should make a motion.
I do have one question before we do.
Yeah, I have a couple questions.
Dwayne or Bert, I'm not sure who this is going to be for. But the piece of, let's see if I can remember it, the driveway, for lack of a better term, that they purchased from the neighbor to be able to gain access to the street. Is there any problem with that?
Well, that's why they're here before you.
I've heard people talk about size, being able to be of proper size to be able to get fire rescue or whatever down there. Is there any issues with that we know of?
What's the width of the driveway?
19 feet, I think.
So technically 15 foot is what the fire department asked for.
And theirs is 19. 20.
It's 20 on the survey we have here, so 20.
Oh, okay, 20.
Okay. Thank you. That was my question.
I have a couple questions. One, Dwayne, one of them is, if the court has already deemed that there's a hardship, clearly, correct? Like, well, that's what we're not here to. We're not the court system here, but they tell us if they see that, we're going to go off of that, just like we go off of the code to make decisions.
So what the court pointed out is that they can't replace your judgment as a board, but what they're indicating and telling you that they found that is a hardship, that if the same facts end up going back to the court, they're going to push it back to us again with the kind of same ruling.
Okay. So, the title, all that stuff, I see, the applicants have tried they seem to be, in my opinion, guys, trying their best to alleviate everything. They've purchased additional spaces, additional lots. I understand that. I also understand going through a year. I've been going through something for 2 years right now with something, right, Bert? So, so I understand that. And as far as if there's, we see you're trying to come up with a solution, and the city, the neighbors, I want everyone to always get along and want neighbors to have a great, community and everything. And unfortunately, sometimes that just doesn't happen. But if they purchase this and they're really doing everything they can, you don't always like what your neighbors are going to do. And so if the court did tell us there's a hardship and they're going to send it back to us, then really what are we doing? We're going to see this again and we're going to be going through the same kind of situation. So what's our resolution from here?
Right, and not necessarily, and to Dwayne's point, the court does not decide for us. So just to be clear.
Well, they're going to kick it back to us.
It's okay. They just don't make the decision.
Yeah.
Otherwise, we wouldn't be here.
Yeah.
Actually, it's not going to go to the court. It would go to the city commission.
There you go. Okay. And you said you had another question. So did we catch them all?
We're good.
We're good? Okay. Jay, your light's on.
I'm just thinking the court determined that there is a hardship, right? So that's determined, and then the question is, does the request before us meet all of the required criteria, which the court was not in a position to make a determination on. That's where we are, right?
So the court's review of this board's prior decision is determining whether or not there was competent substantial evidence in the record to support the decision. Their finding was in the last hearing that the applicant met their burden by preponderance of the evidence to check all of the boxes and deserving of the granting of a variance. That's the court's decision. And they were simply stating that as a rule of law, they are not in the position to tell this board what to do, but they have quashed that order, saying that the evidence upon which the decision was made wasn't there in the hearing. And so it's back before you now to determine whether or not there is evidence here to support the criteria. What I am saying is that the proceedings in terms of the evidence in opposition to the application is not of a different nature than the evidence that was heard at the last hearing. So it is likely that the court would find the same way if you were to deny this application tonight.
Okay, is there any other questions of the applicant before I close the public hearing? Okay, thank you. Close the public hearing, and I'm bringing it back to the board for a motion or any further discussion up here. Jared, your mic's on. Did you want to make a motion?
I mean, based on everything we have, I am going to make a motion to, grant the variance. What's the number here?
Where's it? It's on page 3.
Could you
Sorry. The agenda.
What's this one? All right, section 2724.5. D3E, subdivision regulations, requesting a variance for the proposed side property line segments of Lot 8 per the survey legal description from the requirement for the side lots be substantially at right angles or radial to the street line, allowing the 52-foot north segment of the side lot line turned 90 degrees north to now run parallel to the street line, and to allow the 56.60-foot south segment of the side lot line to turn 90 degrees south to now run parallel with the street line.
Okay. Do we have a second?
I'll second.
Motion and a second. Any further discussion? Okay, Nicole, you're up.
Mr. Shetman?
Yes.
Mr. Galis?
Yes.
Mrs. Williams?
Yes.
Mrs. Rathburn? Yes. Mr. Mead?
Yes.
Chair Elfman?
Yes.
Motion
Okay,
passes.
motion passes. Thank you. Okay. Going to move on to our next case, case number 250-40003, 25 Northwest 11th Street. I'm going to start with disclosures. Jay?
No disclosures.
Doug?
Nothing.
Daniela?
I'm sorry. Which one are we on?
This is going to be on the 25 Northwest 11th Street, case number 3.
It would be nice if they put their address.
Yep, there you go. That's it. Case number 3.
None.
Okay, no disclosures for Daniela. Jared?
No, I do not have any disclosures.
No.
Okay, and Pat, none?
No.
And I did a site visit. And we also have a letter in our file. Okay. Yep. Sorry, we have an applicant, sir. If you could please state your name and property address. I'm sorry, there's a button there if you could press to turn the microphone on.
Okay.
And I'm going to give you 10 minutes on the timer.
Okay.
So there you go.
Yeah, my name is Luke Joseph, and I'm here for Luke's email. Address is 25 Northwest 11th Street, Fort Lauderdale.
And I'm sorry, I'm going to ask you a question. You said you're here for Luke email. What is the relation?
He's
Chair?
my cousin.
Yes.
Just a clarification real quick.
Yes.
Which one is it?
Sure, he'll get that clarification going, but if we would clarify if the gentleman is the agent for this application as you were doing, Chair.
Okay. So is he registered there as the agent?
No,
Is that
go
what
ahead
the-
and continue to clarify that.
Yes.
Yes, I'm the agent. Correct.
Okay. So you have written permission or some type of permission to be able to speak on behalf of the owners?
Yes, sir.
Okay.
Mr. Elfman, can you please state his name again for the record?
Luke Joseph.
Thank you.
Okay. And we're good? Okay. Thank you. I'm sorry. Go right ahead, please.
All right, just to clarify, I'm
Yeah,
ready
go
for
ahead,
that.
Bert.
So in the agenda, it says that they're asking for a reduction from a 6,000 square foot lot down to 5952.
Yes.
That was based on an original drawing that we had where they
Okay.
were going to split the lot directly in half. But now they're actually requesting the lot to be 5952. Oh, no. Where's the other? Where's the new one?
You told me
Yeah, 5251.
So 52, 51 instead of
So
59,
they're making the
52.
lot in the back 63 feet, and the lot they're splitting off, they want it to be 57 feet. So it's a little bit smaller lot than what's on the agenda.
Okay.
So
there-
instead of 5952, it's 5251?
That's correct.
And the other lot is going to be sufficient size?
Yes.
Okay.
The other lot's 6,300 square feet.
And you said the back one is 5251, correct?
The
Or is it side by side?
The one to the east. The one
Okay.
in question that we're talking about today.
Okay. The one east, which is along Andrews.
Yeah.
Okay. Sorry. We're going to try for a third time. Go right ahead.
One night in 52, 53, a portion of our lot was given to the city to enlarge Andrews Avenue. And that's the reason now we wanted to subdivide into two lots. And that created pretty much a little bit of issue for us. And that's the reason we're here to be asking the board to grant us the variance so we can build a single family on the other lot, which is going to be a little bit smaller than the 6,000 square foot required by the city.
Okay. Is there anything else that you wanted to add?
Nope.
Okay.
That's it.
Don't go too far. May have some questions for you.
Thank you.
Is there anybody from the public wishing to speak? I have Olga Zamora. Is it? Okay.
Do I need to be sworn in?
Yes, if you have not already. Nicole, if you could, please. Thank you for asking.
You raise your hand. Do you swear that the testimony that you give will be true, the truth, the whole truth, and nothing but the truth?
Absolutely.
Thank you.
Good evening, Chair, members of the Board of Adjustment. My name is Olga Zamora. I value this opportunity to submit questions in my personal capacity as a homesteaded property owner in the South Middle River neighborhood. I live within 500 feet of the property. I am not in opposition or in favor of this case. What I would like is some clarification to 5 very specific questions I have. And as an informational note for the board and anyone who's interested who does not live in the neighborhood, over 15 years ago, South Middle River in District 2 was deemed as having slum and blight and in need of revitalization and beautification. This is why it belongs to the Central City CRA. The property is within Central City CRA. It's on the corner of Northwest 11th Street and North Andrews Avenue, directly diagonal from historic Warfield Park. There's Broward County's half-cent tax will beautify North Andrews Avenue from Sunrise Boulevard to Oakland Park Boulevard with plantings of trees, better street lights, wider sidewalks for pedestrians and cyclists, and so forth. Our neighborhood is in need of beautification. So the 5 specific questions I have, which I would like to ask through the chair, I can ask them individually and wait for an answer, or I can list them out and then just have whatever the chair, whatever you'd like, I would like to ask.
Well, the questions are going to probably be for staff.
Okay.
Because I did read your email.
Thank you very much. So the first question that I would like clarity on is the property appraiser's website says that the lot is 12,007 square feet. The property owner's answer in page 2A, criteria D, they indicate that their lot is 12,006 square feet. Why does the property owner need a variance to achieve the minimum lot size of 2 lots for 6,000 square foot each? Is the property appraiser's information wrong, or is their surveyor wrong? That's the first question.
No, they're not splitting the lot directly in half. They're giving the westerly lot more land than the eastern one. And so the eastern one is now less than the required minimum 6,000 square feet. It's only 5,251 because they're not splitting it down the middle.
So the 12,000 square feet is still a wrong number in the property appraiser's website. Is that accurate?
I don't know where
It's
they
in the
get their
backup.
information of, but it's around 6,000. But when you take a 12,000 square foot lot and you put 7,000 on one lot and 5,000 on another, you're creating a non-conforming lot. One lot, the one in the back is 6,300 square feet, and then the one in the front is not. It's less than 6,000. So by disproportionately splitting the lot, it's creating a smaller lot to the east.
Thank you. I completely understand that just the math isn't mathing with the 12,000 and the 11,500 discrepancy.
And Olga, let me stop you for 1 minute, because I do know some of the questions you're going to ask, but we need to ask questions really pertinent to us making a decision to grant a variance. So and we are out of time, but I'll give you another minute if there's anything you have for the board to be able to,
Sure.
that has to do with us granting a variance. or
Sure.
not.
So are there any conditions, if it is the will of this board, are there any conditions that the board may ask of the applicant, or that is within the board's purview if there is an approval for this application, to ensure that the property owner does not continue to incur code violations?
That would be outside our purview. What else?
Okay. And the rest of the questions are in the email that I submitted, so I thank you for your time.
Thank you. Is there anybody else from the public wishing to speak to this matter? Okay. Seeing that's none, I'm going to see if the board has any questions for the applicant. Board, do you have any questions? Okay. Seeing we have no questions for the applicant, I'm going to close the public hearing, and I'll bring it back to the board for a motion or any internal discussion. I could play some Jeopardy music.
Actually, I did have a question. I'm sorry.
Go ahead, Pat.
And that is why they aren't splitting it. Maybe staff can answer this, but why is it because setbacks on the existing structure would require that if they split it exactly down the middle, then the structure would not be in compliance with the code, with its setbacks? Or I just wondered why they're not splitting it down the middle.
I think it's a vacant lot.
What?
Is there?
Yeah, there's a structure on, there's a structure on one of the
Yeah,
lots,
where
right?
Where they're proposing to split it, it only leaves them a 5.3.
I'm sorry?
Where the way they're proposing to split, it leaves the existing structure 5.3 feet away from the property line, so that is why.
With a
they're-
5 foot, yeah, okay, all right, so that's the reason that it's not going to be an even split. Okay, thank you.
Okay. Doug, did you have a question?
I was just wondering how this is a hardship. It's a preference, but is it a hardship?
When I can ask a question right to that.
Let me reopen the public
sorry.
hearing, and now you can ask a question to the applicant. All right. Go ahead.
When did the city and how much did they take away from you guys when they built Andrews?
I'm not 100% sure, but from 15,000, now we are 12,600, from 15,000.
Okay. It happened how long ago?
50 to 53.
Oh, okay. So it's been a long time. Has the family has owned the lot all this time, the space all this time?
No, we purchased from somebody else.
Okay.
So to answer the member's question, on the page 2 of the survey, it shows 15 feet from the original platted lots on Andrews Avenue. We're taking for Andrews Avenue, rather.
Is there another question of the applicant in the meantime? Doug, I guess you could re-ask your question of the applicant, if you wish.
Why is this a hardship? I mean, you have 12,000 square feet, and it's not that your house is encroached. You're making where the house is the smaller one.
No, because I wanted to split it into two, 6,000 and one, 6,000 the other, but because of some issue, the city says I was not able to because of the setback from Andrews, and they really curve and it will be short. But my original plans was to divide it into two.
So
Bert, maybe
can
you
you
could
clarify that?
Please repeat that.
Sorry, he was saying that
He wanted to split it in half, and somebody suggested that he can't.
It was probably said because of the setback.
Yeah, because of the setback.
Because of the 25 feet on the side and the front?
No. I believe we're in the corner of Andrews and 11th Street. There's a little curve. There were curves, and this says because of that little curving, and I lost like 3 feet, 2 feet or something and such.
Okay.
I guess I have one question of when we were at 59, 52 square feet, we were pretty close. Now I understand we're at 52, 51 square feet.
Honestly, I did not know about the 52, 50. I thought it was 59.
Okay.
Something so. Even stated in the paperwork, it was 59. So
I mean, I don't have a drawing here of where you want the line. How, out of 120 feet, where are we putting where you want to split it?
Half in the center.
Well, that would be 60. So you're splitting at 60 feet, and it's just coming out less because of the curve.
That is correct.
Okay, thank you.
Okay. Jay? Oh, your microphone was on. Okay. Jared, did you still have a question? I see you searching through. No? Research?
So,
okay.
And
Go ahead,
I'm
Elaine.
interjecting a whole lot today. I apologize, but I just want to make sure that the record is clear. So what we have is a survey, and on sheet 3 of the survey, you'll see the outline of the smaller lot, and that is the lot that has the 5250 square feet. So that page 3 shows the width coming from the new eastern property line going west to be 53 feet. And then if you look at page 2, you'll see the other lot, and that distance from east to west is 67 feet. That lot is 6,700 square feet, and the parcel B is 5251 square feet. I'm a bit confused a little bit by the testimony. Is the testimony that what's on the survey is not what the applicant is seeking?
According to what I saw, there was the original my original application was to split it into two, 6,003, 6,003. I was informed that I would not be able to do. So I went back to the surveyor. I did that survey 3 or 4 times to make the corrections, the proper corrections for the city to be accepted. So the final one was requested by the city, was accepted by the city.
I'm sorry, it just makes no sense to me.
And
Why
basically-
you do this? I mean, it's fine if you want to do this, but it doesn't make any sense why you would make what you want to build on smaller than where you already have a house.
Because they said I could not change the existing one.
Yeah, if it's 5.3 feet from the east line of the existing residence to where he is going to draw his new lot line. The most he could move it, the largest he could make that lot would be to move it 3 inches closer to the house, because the house has to have a 5-foot setback from the property line. So,
Yeah, what about the other 28.7 feet?
I'm sorry?
There's 28.7 feet beyond that 5.3. His house is 28 feet wide. He's making the 67.
No, it's 28 long to that. Then the house seems to jut. The house isn't square.
Okay, so it's 33 feet.
Yeah, it's 33 at one point. It's 28 at the other end. It's
Okay,
28.1.
But beyond the 33.5, there's another 28.7 feet to where he's putting the line.
Yeah, but he has to be at least 5 feet back from the lot line for the portion of the house. And I think he is actually. If you look at the green line is the lot line. Bert, am I correct
The green
here?
line's the house line.
The green line is the house, and he's 5'3" from the house to the other.
No, the 5.3 is the difference between 28.2 and 33.5. He's dividing
Yeah.
the lot 28.7 feet to the right of that.
So Mr. Joseph, just trying
Don't make me do
to
math.
be clear here. Your testimony tonight has been that you just want to divide the lots equally.
Into 2 equal lots. Yes, correct.
So is your surveyor the one that's working with city staff? Or are you the one that's communicating with them? The revised survey that we have before us with the different size lots, who directed your surveyor to prepare that?
After I spoke to Mr. Burns' office and Mr. Karen, and they were informed me that I had to make those requests to the survey because of the way it shapes, because they said I could not change the original property size lot. So any correction has to be made on the other one and the empty lot.
And
and that was the understanding.
And those individuals reviewed the changed survey?
Correct.
Bert, I'm looking at your face, and it seems like you have something that you could add here to help.
I don't think I have any firsthand knowledge of this because I was on vacation when this was reviewed, but there doesn't seem to be anything in the paperwork that would make us tell him that he couldn't split it down the middle, because that's what it was originally supposed to do. If you look at the third sheet, you can see that where I said it was 5.3, it's actually much farther away from the property line than that. It's 28.7 feet from the eastern property line. So there was no reason that he couldn't split it in half. I don't recall ever telling him that he couldn't, nor does staff that I just talked to remember telling him that he couldn't. So it may be beneficial to.
I may make a recommendation, which I think is what you're saying, and Dwayne, you tell me if I'm off. But sir, I would almost recommend that you ask for a deferral on this, because it seems like there is a possibility you may be able to do what you initially wanted versus us forcing you into something one way or another with what's in front of us.
Okay.
So I would ask you to ask for a deferral until the next meeting so you can get this straightened out.
That sounds good.
Okay, I'll take that as he is requesting it.
Motion to defer to the next meeting.
Second.
Okay, motion second. Any discussion? All in favor, aye? Oh, there we go. I'm sorry, I just did it that way. We're going to do it the right way. Sorry, Nicole, go for it. Wrong board. Go ahead.
Yes.
Roll for a motion to defer
Yeah.
to January, what date?
14th, I think.
14th. 14th
Yeah.
meeting.
Do you want to just do a roll call?
Yes.
Sorry, we'll do it right.
Yes, that's right. Mr. Stratman?
Yes.
Mr. Galis?
Yes.
Ms. Williams?
Yes.
Mrs. Rathburn?
Yes.
Mr. Mead?
Yes.
Mr. Elfman?
Yes.
Motion passes.
Thank you. We'll see you at next meeting.
I'll take it.
Okay, next case. Case number 25110004, 1668, Southwest 24th Street, number 1 and 2. First, we'll start with disclosures. Jay?
None.
Doug? None. I did a drive-by. Daniela?
None.
Jared?
None.
Pat?
None.
Okay. You're up. Thanks for your patience. Please state your name and property address.
Hi, I'm James Doherty. I'm the owner of the lot. And I also live 2 houses down from that lot with my wife and kids. I bought this property in 2022 in an effort to bring up the street and the things that are going on the street because I live there with my family. That property was distressed. There was a squatter living there. So I had an opportunity to buy it with the intent to renovate and make a garden. And there was a flood that came through the neighborhood. Ended up having to rip the floor out and the drywall. When I did that to fix the flood damage, found out that there was significant foundational cracking to the walls and the floors from large oak tree that is next to the house. So at that time, I decided to knock that house down. And I'm looking to develop a newer development there now with a higher elevation so it doesn't flood because that area is very prone to flooding. When I bought that lot, this road that creates the corner setback, it was just a dirt road. When they came in and did some storm work, the city did some storm work to enhance the system there. They ended up paving that road. So I'm looking to build a 2-unit dwelling on that road, or on that lot. And right now, with it being a 50-foot wide lot, having a 12-foot setback from the corner presents some problems for the 2-unit dwelling. The neighbor behind me doesn't have the 12-foot setback that they're asking me to have. So I was looking for a variance to be able to do that. Requesting a 5-foot setback on the side there. If you guys are opposed to the 5-foot setback, I'd be willing to hear other alternatives that maybe you guys would be okay with to see if I could work with that. Thank you.
Is there anything else you wish to add at this time?
No, not right now.
Okay, thank you. Open up the public hearing. Anybody from the public wishing to speak to this matter? Okay, seeing that there's none. Board, do you have any questions of the applicant?
No question. So on the side where you want 5 feet, that's 5 feet from your property line. What's
Correct.
the distance from your property line to the asphalt?
So that road, it curves greatly at that area. So in one area, if I told you
Ballpark.
exactly.
No, just 5 feet, 10 feet,
From
15
the
feet.
road, it'd probably be 15 feet from the curve point and maybe 10 feet from the non-curved point.
Okay, thank you. And this is a limited road. This used to be dirt, so there's very little traffic on it.
Correct. It's just for I don't even know why it's there. There's a couple of houses on that road, but there's no through traffic on that street.
Okay, thank you.
You're welcome.
I know it was a hard U-turn.
Yeah.
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 Anybody else have any questions for the applicant? Okay, seeing that there's none, we'll close the public hearing. Thank you, sir.
Thank you.
And bring it back to the board for a motion or any discussion. Anyone like to make a motion?
I'll make a motion.
Go ahead, Doug.
Make a motion to grant the variance for section 47-5-32. Is that all I need?
Second.
Okay, we have a motion and a second. Any further discussion?
I'm
Okay.
sorry.
Yeah, go ahead, Danielle.
I want to get out of here, but I do need to say something.
Sure, please.
Why would we like what is the rest of the makeup of the neighborhood? Because from what I'm gathering is this is a want, not a need. He's looking to place a two-family or a two-home or a townhouse development there, whereas if he were placing a single-family home there probably wouldn't be need for this variance. So how is this a unique issue? How is it a hardship issue? I don't see how this satisfies the requirements before us.
Okay, Jay.
I was just going to ask if you can please speak into your mic. It's hard to hear you over here.
Oh, the mic's not on.
No, it wasn't. It wasn't.
I think I caught everything you said.
Sorry, I'm
but,
getting
yeah.
I'm getting a little hoarse, to be honest, so my voice is a little deeper. I was saying that it sounds like he wouldn't have a need for this variance if it were for a single family home versus a townhouse type of development. So I don't understand how this is a unique issue or how it's a unique hardship. And maybe, you guys could help me understand exactly why that this would fit the criteria in front of us.
Would you like me to open up the public hearing? You ask the applicant?
Sure.
Okay, then in that case, I'll reopen the public hearing, and we're going to ask the applicant. And sir, just put your microphone on, and I think you heard the question.
Yes, I did.
Okay, so
So for personal reasons, I live there with my family, and I need 2 units to be able to move my mom into one and my wife's mom into the other as they're getting older. So to have them in one house probably wouldn't work out too well. So the idea is that I have 2 units that they each could live in one without killing each other.
But that's a want, not a need, right? That's not a unique hardship that you.
Well, the hardship is that right now this property is undeveloped and there's a park across the street where there's a lot of activity that's undesirable, especially at nighttime. And I feel like because there's a vacant lot across the street, there's all sorts of people parking cars and doing things that you don't want your kids around.
But you could build a nice big single family home on this lot without the need for a variance, right?
Yes.
No more questions for me. Thanks.
thank you. Is there any other questions of the applicant? Jay.
So basically it's it's being considered a corner lot because it's got a road. So the setback, rather, if it were just next to sorry, I think this is for staff. Yeah, it would be 5 feet. So, but right, and there are reasons that we have bigger setbacks for corner lots for visibility, traffic, so on and so forth. Correct? Okay.
Yeah, and
right. Okay. So now I'm just going to say like some thoughts that I have to my colleague, which is that like he probably can build also still 2 units on it, right? Just he could still build 2 townhouses on it. They just would have to be set back further. Is that also correct?
well, if they had to adhere to the 12.5-foot corner yard setback, the building would be more narrow.
It'd be narrow, but he could still do 2 unit. He could still do townhouses on it.
I don't know if I can't answer the question. Could they? Yeah, you could build a 10-foot wide house if you wanted to. Is it practical? I don't know. And I don't really know how big of a house they could build because I haven't looked at it in that way. But you can build anything, but is it practical? And, I'll let you guys discuss that.
Okay, I'm just thinking like in Tarpon River, where 7th Street and 7th Avenue meet, there's a corner lot and there's 2 townhouses that they just built on it, and they're kind of boxy, but they're like, it seems that they didn't get a code variance to build that, right? So I don't think that really changes anything. And, you know, I don't think that the applicant has like articulated like a true hardship, but it's not our job to determine if they, you know, they should articulate a hardship better. But in my view, there is a hardship here because the lot setbacks are being determined as if this were a typical corner lot, and the requirements are as if it's a typical corner lot, and it's not, because one of those roads isn't really a typical road.
Go ahead, Pat.
Can I ask a question of staff? So he's asking for a variance to allow the corner yard to be 5 feet where the code requires 25% of the lot, but not less than 10 feet. A reduction of 7 feet 6 inches. Where does that 7 feet 6 inches come from?
25% of 50 is 12 and a half.
Good point. I asked you not to embarrass me, make me do math in front of people. But he also said that, you know, he wasn't married to 5 feet. So if he had the minimum, which would be 10 feet, he still would need a variance.
Yes, he would still need a variance. That's just in there so that if you do have a lot that's less than 50 feet, you know, and the 25% came down to say 8 feet, it still has to be 10.
Okay.
Okay. Anything else for the applicant? Okay. Thank you again.
Thank you.
Public hearing is now closed again. And I'll bring it back for a motion.
We did a motion.
If we have one. Did we do a motion?
We did a motion and seconded. Yeah.
I missed it too.
We did?
I did the motion.
What was the motion, Nicole? Okay. Somehow half of us missed it, so I'm glad that we have you to get us covered. Okay, so we have the motion and a second. Now we could, no other questions? Let's call the roll.
Mr. Shetman?
Yes.
Mr. Gayless?
Yes.
Mrs. Williams?
No.
Mrs. Rathburn? Mr. Mead?
Yes.
And Chair Elfman?
Yes, motion passes. Thank you. Next case, case number 25110003, 640 Northwest 7th Avenue. We'll start with any disclosures. Jay?
Yes, I was reached out to by applicant's counsel.
Okay. Doug?
Nothing.
Okay. I had spoke to applicant's counsel, and also I did a site visit. Daniela?
No.
Okay. Jared?
Yeah.
I got an email from council.
Okay.
I did as well.
Okay.
Good evening, it's Stephanie Miorga with Stephanie Toothaker's office on behalf of the property owner and developer of the Arcadian. For context, the Arcadian is a mixed-use, mixed-income development that's located at the intersection of Sistrunk Boulevard and Avenue of the Arts. 10% of the units are deed-restricted affordable housing units, and we are anticipating partial certificate of occupancy issuance sometime this month, with residents moving in as soon as January. And we're here tonight regarding the proposed art canvases that are located screening the parking garage fronting Avenue of the Arts and Northwest 6th Avenue. Our client, the developer, engaged a very well-known international artist known as Mr. Brainwash. And the artist really put a lot of thought and effort into the artwork. He's really commemorating the history of Fort Lauderdale. He has everyone from the likes of Dr. Sistrunk, Dr. Mizell, local historic landmarks. So he put a lot of thought into the artwork. And the reason why we're here tonight is regarding the lettering that's part of the art composition. It states, "Life is beautiful, love is the answer." And unfortunately, the latest interpretation that we got from city staff was that any lettering would require a variance request, even if it's part of a art composition and not commercial in any way. So I just want to walk you through the chronology of events. We initially, before we submitted anything to the city, we showed the artwork to city staff, and they advised that because essentially the art displays would be considered a sign. So we submitted a super graphic sign permit. At that point, we were advised that because of the artistic lettering, we would be required to submit a site plan level 2 application, which is essentially a higher level of review that only properties in the regional activity centers where this property is located, you could avail yourself of that process. And essentially, city staff has the discretion of approving it. It's subject to a city commission call-up period. We submitted that application, but it wasn't until further staff review and this latest interpretation that we received that the more appropriate path would be to request a variance, which is why we're here today. So again, this is the code section that we're requesting a variance from. It's from the super graphic sign definition. It states a design or pictorial representation that contains no lettering or business identification or logo used as a sign as defined herein. Again, I just want to emphasize that this is not commercial in nature. It is not affiliated with the Arcadian development in any way or with any of the businesses that are located inside the building. It's purely the lettering is part of the art composition. So special conditions, we do feel that there are significant special conditions. There's no other sign type that we qualify under. This is the super graphics is the closest sign type that we qualify as, with the exception of the no lettering language that's in the code. And peculiarity of the conditions, again, this is not commercial in nature. It's strictly art. Deprivation of substantial property rights. Again, it's not just to beautify the property. It's also intended to screen the parking garage. So there's a functional purpose behind this artwork. Unique hardship, not self-created. Again, this is really, I think, our team thinks that this is a code gap in the current sign code. The sign code is a little bit antiquated. We've run into issues before with it. And this latest interpretation states that no lettering of any type, even if it's artistic, wouldn't be able to qualify under a super graphic sign permit. And again, this is the minimum variance necessary, and it's totally intended to be in harmony with the surrounding projects. It's intended to screen the parking garage. So again, it has a functional purpose behind it. And with that, I'm happy to answer any questions.
Thank you. Is there anybody from the public wishing to speak to this matter? Seeing none, I'm going to bring back to the board for any questions of the applicant.
I have a question.
Go ahead, Doug.
If the purpose of this initially is supposed to screen the garage, it's not screening the garage.
It is screening the garage.
It's screening two levels, not,
Right, but pursuant to our approved site plan, this was approved as is. So it is complying with the city's screening criteria.
Okay.
Yes.
And what about visual clutter?
Visual clutter, in all of the respects, we do comply with the sign code. We're only here tonight for the lettering. So we do comply with all other aspects of the super graphic sign code.
Could staff define what visual clutter is?
I think that's subjective, though. In my opinion, it's
art is objective. Clutter is not.
Go ahead, Bert, if there's an answer that you have.
To my knowledge, they're only here for the lettering.
That's correct.
I have a question for you. If the lettering wasn't on there, would it qualify otherwise?
It would qualify as a super graphic sign permit, but again, there's no other sign type that we would be. The closest that we resemble would be super graphics, with the exception of the lettering. But again, it's part of the artwork as commissioned.
Okay. Any other questions for the applicant?
So I do have a clarification based on based on the narrative and the presentation. I know the code section referenced overall as the general section for super graphic signs 47-22.2.3S. However, the distinction that prohibits the lettering is found, and this is referenced within the request, is 47-22.2A27. So just for clarification, the issue here is that this particular sign contains lettering, and that particular code section says that design and pictorial representation that contains no lettering or business identification or logos used in the sign, and that's the issue?
That's the issue, correct?
Okay, so we would I'd suggest revising in terms of if the board is looking to grant the variance, that it be a variance from section 27-22.2.A.27.
And I'm not sure if this is a D. Wayne question or probably a Bert question. Bert? Oh, Bert. Okay, James, do I have a better chance with you? The question is the Mr. Brainwash considered a logo?
Yeah, that was my question.
That's, I'll defer to
Well,
staff.
because
to answer that.
it's not part of the representation that contains no lettering or business identification or logo. I think that it can be argued that the words, I forget what the words are. The words, life is beautiful and life, whatever, love is the answer. That might be considered art, but then the Mr. Brainwash is the logo. It's almost as big as that. So that's, and, it's not our job to sit here and talk about whether art is art, but that looks like a logo.
I would just want to add that is the artist's signature.
Does it have to be that big?
If Picasso, is Picasso's signature a logo?
Yeah, but most art signatures are not the major piece of the art.
Okay, before we bring it back, any other questions for the applicant? Okay, thank you. And it's Estefania?
Estefania, yeah.
Okay, thank you, Estefania.
Thank you.
Board, bring it back here.
I was just going to say, even if Mr. Brainwash is not a logo, it still could be a business identification, which is kind of a trademark name for him.
I think the reality of life is that if this matter is denied, it will go to the city commission for review, and it may be that the city commission substitutes their judgment for ours. So I would rather make a motion to grant this with the very strict provision that it's for these super graphics only with this exact language, and that any other language, any other writing, any other words would not be included in the variance, and at least take some control over the item.
I like where you went with that.
Just to clarify, the art as presented in this request. Exactly. That is what we're proposing
But
tonight.
if I make a motion for the variance, it would be limited to this exact language, and any other language, any increase in the size, any change in the art as presented to us would not be under this variance.
Yeah, we would accept that condition as long as it's exactly what we presented in this presentation tonight. That's the intent.
Okay. I actually closed the public hearing, so
Okay, sorry.
That's okay. Jay.
That's fine, but just out of curiosity, I know it's late, but I mean, I have no problem doing it. It sounds like they'll accept that, but that's obviously, is that redundant? I mean, is that necessary? Doesn't our approval?
We
No,
cannot do that. You
I
can
think it's relevant. So
Okay.
What was mentioned was a change in policy, and this came about, and it's not necessarily a change in policy, but the Supreme Court had a couple of decisions, starting with the Reed decision, that dealt with sign regulation and the constitutionality of regulating the actual words on the signage. So for a long time, we were able to regulate signs based on reading the content of the sign to determine the category of the signs. But the Supreme Court said, no, that needs to be strict scrutiny, that if you read the language, you need to your regulation has to go through particular tests with regards to the First Amendment. So our regulation has to be content neutral. So any sign, we can't regulate what people put on the signage. But we can regulate as it relates to on-premises signs, right? So, so when it comes to graphics that contains lettering, regardless of what the lettering says, because in the past we could say, well, this lettering isn't related to a business. It's, we can base it on the content of the lettering to determine whether it's art or not. We don't have that discretion anymore. All right. So anytime there is lettering, it's a sign, and we have to figure out what category of sign. So I think it would be prudent in this particular case, as they're asking for a variance, for you to consider this a super graphic display, for this board to, in essence, you're determining that those letters are a super graphic display versus some other type of lettering and sign advertisement, and thereby limiting it. You meet that purpose and the intent, and I think that's what the applicant is looking for as well.
And so if we said that we are approving the variance for this artwork only and not even mention the words, this artwork
Correct.
only
Correct.
would cover what you're concerned about and would cover what we're concerned about.
Absolutely.
Okay. So, you ready for more?
And could we give them the option of making the words "Mr. Brainwash" smaller?
You talk to Mr. Brainwash about that.
Are these actually printed yet?
I believe they might be already.
If you're ready
That was
for
probably
motion.
not good.
I'll-
Go ahead, Pat.
What?
Go ahead.
Okay, my motion is to grant the variance for, let me see. I have too much paper. From section 4722, and Dwayne, 4722-2A27, is that correct?
That's correct. And
Okay.
let's add the other section in for good measure.
Okay. For a super graphic sign with this specific artwork presented only for the specific artwork presented for the east side frame and the west side frame as contained in the application.
Okay, do we have a second?
Second.
Okay, any discussion? Okay, Nicole?
Mr. Shepman?
Yes.
Mr. Galis?
Yes.
Mrs. Williams?
Yes.
Mrs. Rathburn? Yes. Mr. Mead?
Yes.
Chair Elfman?
Yes.
Motion passes.
Thank you.
Thank you very much.
Okay, last case of the evening. Case number 251-10005. And we'll start with disclosures. Jay?
None.
Doug?
None.
Daniela?
None.
Jared?
Nope.
Pat?
None.
And I did a site visit, and I just want to bring this up front. I did not see any Board of Adjustment meeting signs when I was visiting the site. So I will leave that to the applicant to see how I may have missed something. But the applicant, if you could please come on up, state your name and property address. And I'll also set time for about 10 minutes. Should that be ample time for you?
Sure,
Okay.
yes. Good evening. My name is Rob Orcutt. Here representing the client for 934 Waverly. And we are here to request basically to maintain existing setbacks for an existing structure that we're proposing to rebuild.
So, Chair, you raised a procedural issue.
I did.
In terms of signage and notice, do you have proof that you've actually posted the required notice sign?
Yes.
I don't think staff has that. So do you?
Yes, we did send that in with the affidavit. signage on the front of the property as well as the waterway.
Okay, I did not see the waterway because obviously I wasn't able to go back there. For the front of the property, I was there on Saturday. Any chance that it came down and back up? Okay, but it's provided to staff? Okay. Okay, well, I'll leave it as an option that somehow my eyesight might not have been as good as it should have been. So I'll give into that, and sorry, I'll let you go right ahead.
Okay, thank you. So this property is located at 934 Waverly Road. It's within the Sailboat Bend Historic District. And is uniquely located along the river. It's highlighted there at the bottom of the property. The property was purchased by the client for its unique position along the river, and he came to us wanting to renovate and update the structure, which we approached the Historic Preservation Board last year. The project included raising the existing structure and infilling the ground floor, so basically a ground floor addition to add to this historic structure. This is the current structure and its position in the new project raised on top of the new infilled ground floor. This was approved by the board, Historic Preservation Board. Here we're showing that the structure is located directly adjacent to the river on the south side, and is also abutting pretty closely to the west property line. And that is why we're here today to request those two setbacks. So, as I mentioned, the project was approved by the Historic Preservation Board. After it was approved, we started the process, planning construction, and initiated a structural analysis to start planning bracing and requirements for moving the structure to be able to build the first floor and rebuild the foundation. When we got into the structural analysis, basically the entire structure was uncovered to be not suitable to be moved. Extensive termite damage. We made several openings in the walls. And throughout the report, these are just a few photographs. But the structural engineer determined that the structure could not be safely moved. A few more photos. So with that, we went back to the Historic Preservation Board and requested that we be able to rebuild the portion of the structure that was not able to be salvaged. Their determination was that they could not approve the project with the same requirements that it met before with the setback waivers that were granted for that project due to the fact of the extensive damage and replacement requirements of the structure. This is an aerial view of the property. You can see the structure as it sits along the river, the North Fork of the New River. It has a very unique character, and that's what we're here to request to preserve. Without variance being granted to maintain this structure and its current setback, we wouldn't be able to preserve it. As I mentioned initially, the project was approved by the Historic Preservation Board, but the level of reconstruction required to make it possible We were told, it actually got rejected, and we were told that it's beyond the extent of preservation. So we're here requesting the side yard setback, which directly abuts City Park on the west side. It's the green space. On the east side of the property is actually the current homeowner and current property owner of this property. So there's no, they're definitely in support of this project. We've also heard from, during hearings at the historic board, we've heard from other neighbors that do like the structure and its appearance on the river. And our goal is to preserve that that character, really, for this, for the next generation, for this structure. The city has also, spoken in hearings about the unique appearance of the structure, as it's situated along the curve of the New River, having a picturesque presence reminiscent of a traditional boathouse. And that's what we're here to try to preserve.
Okay. Is there anything else you'd like to add?
That is it.
Okay. Don't go too far. We may have some questions for you.
Sure.
Is there anybody from the public wishing to speak to this matter? Seeing that there's none, I'll bring it back to the board. Any questions for the applicant? Okay. I'm going to ask a question. So we're going to be in the same footprint of what it was?
Exact same footprint, yes.
Okay. Okay. If there's nothing else for the applicant, close the public hearing. Board, anybody like to make a motion? Or any further discussion?
There was a picture, right? It was the aerial view, and you could see the bridge going over. Can you
Correct.
put that back up, please? Okay. So I don't know the applicant, but this is my neighborhood, and I go over this bridge. It's the last remaining swing bridge in Florida.
Yes.
Yeah, almost daily. And you do look to the right there, and you see that little house over there. And that thing over there is a big Spanish old house. They're renovating that. It's beautiful. But anyways, so no, as a fellow neighbor, absolutely love the thought of it being replaced by something that is similarly situated, and it is a historic district. So I can't see a reason not to.
Thank you.
Go ahead, Doug.
I mean, it is a great house, but you're taking it down. You're not putting up the same. It's not like you're saying, I want to put up the same thing. You're putting up a two-story modern-ish house in the same spot. So it's not like you're saying, I want to do a little cute boathouse there. So it's not exactly historic anymore.
It is the same exact structure on the upper portion of the house, but we are infilling the ground floor.
And the character of what they've proposed does look a lot like the character of the other houses in that neighborhood. And I hate these new houses. So.
With that, would you like to make a motion?
You went from raising to raising.
You don't have to read it all.
Raise versus.
Oh, sorry, Jay. Is this a question for the board or for the applicant?
For the applicant. Was this
Then in
what-
that case, could I open the public hearing again?
Oh, yeah,
Okay.
sure.
Could I open the public hearing again? Sorry, glad you're still there. Go ahead, Jay.
Was this were the properties one parcel at one point, and when were they subdivided?
I don't believe so, no. Subdivided from
each other.
They were one property at one point, because I got some from the 30s from the city, and I don't know what they were subdivided.
This was the boathouse for the house they still live in.
I guess so, yeah.
Okay.
At one point, I didn't see the full diagram of it.
Okay, I'm just wondering, maybe that's why you're confused with the like, does it have a different address? So this is 934, and the one to the east is.
930 West and 1 Waverly.
Okay. Yeah. So just side yard setbacks and rear yard setback variance.
Correct. The request also includes the roof overhang. Once you have a smaller setback, it's a percentage, and it calculates to like 0.57 allowed for an eave. So this request would include the eaves.
Okay, thank you.
How high are you raising it? You're obviously raising the level.
It's a full floor level.
I'm sorry, what?
Yeah.
You have to speak.
But you could tell him. He could.
You can
tell
speak in the mic.
It's roughly adding 11 feet to the first floor level to the existing structure.
I'm confused. And what's the first 11 feet? Is this 2 stories now, or
Yes,
story is raising up?
It's currently 1 story.
Right.
We're raising it and adding a story below it.
Okay. So how high off the ground, the lower story, how high off the ground is that going to be above the river? Oh, sorry.
It's going to be maximum 20 feet at the setback line, but the roof line the hipped roof extends higher than that.
No, floor.
The floor.
I mean, everyone in town is raising everything up.
So the floor we're required to meet the minimum flood zone requirements. So that's what we would have to meet.
Which is
7.0 NAVD. And that's about 2.5 feet taller than the current structure.
Okay. Thank you.
So yes, it does need to meet. It'll be raised slightly to meet flood zone plus the additional first floor.
Okay. Jay, did you still have something?
No, thank you.
Okay. Okay. Thank you again. Close the public hearing unless there's still a question. Is there a question of the applicant, Pat? Okay. Then in that case, close the public hearing. Entertain a motion from the board.
Make a motion to approve, based on the uniqueness of the property. The 1.7 is not something I would normally grant, but it's adjacent to a city park, so that's not impacting any other property owners. And it is a unique property because of that and because of its historic nature. So make a motion to approve the variance from section 47-5.31 table of dimension requirements and 47-19 to be architectural features in a residential district.
Okay. Do we have a second?
I'll second.
Okay. Motion and a second. Any discussion? Okay. Nicole?
Mr. Shepman?
Yes.
Mr. Galis?
Yes.
Mrs. Williams?
Yes.
Mrs. Rathburn?
Yes.
Mr. Mead?
Yes.
Chair Elfman?
Yes.
Motion passes.
Thank you.
Thank you.
Before we go and before we give our communications, we do have to decide on our 2026 meeting dates. Oh, I need all that. Okay, are we making any motions on this, or are we just talking about these are our new meeting dates? Shaquilla?
So basically, it's going to be for you guys to, take a look at it, vote on it, if the dates are okay. I did want to disclose that the November 12th date that was originally placed in the package, it should be November 10th. That was originally sent to you guys on October 8th. I just wanted to make sure that you guys know that. Second Wednesday. Yes. Well, in this scenario, it's going to be on a Tuesday because of Veterans Day. Correct.
That particular meeting, November.
Yes.
Okay. Okay. Does anybody have any discussion they want to do on this, except for the one change, which is on a Tuesday night. So don't show up on a Wednesday. You'll be by yourself.
I think we'll hear from staff sufficiently.
Emails, text, phone calls.
And there's no way we can move September one way or the other, being it's Labor Day week.
I mean, I guess we would have to have a week. I mean, what would you propose?
Either the week before or the week after. Just a weird year because Labor Day is like the second week and not the first week like normal.
But isn't it Labor Day Monday?
What?
Isn't Labor Day on Monday?
Yeah, but it's Labor Day week.
It's the 7th.
So there's a lot that goes into.
You can say no if you want to. That's fine.
I just want to, so we would have to.
Pretty good. No.
Okay, so do we have to take a vote on these meeting dates as proposed? Or is it just informational?
You have to take a vote on the change. So the
For the change of November 10th change?
Yes.
Okay. Do we need a motion for this?
Motion to approve the meeting schedule as presented.
Okay, do we have a second? Second, hello?
Second.
Thank you. Any discussion? Nicole?
Mr. Chapman?
Yes.
Mr. Galis?
Yep.
Mrs. Williams?
Yes.
Mrs. Rathburn?
Yes.
Mr. Mead?
Yes.
Chair Elfman?
Yes.
Motion passes.
Okay, thank you. Is there any communication to the City Commission?
No, but Chair, I did want to discuss, a few weeks ago, I sent an email to everyone regarding iPad usage as opposed to our paper, packages. We wanted you guys to feedback on that. We were proposing January 14th to begin that.
So I want to clarify, because I know we went back and forth. So we're going to get an email package, and then we're going to be able to use, instead of bringing our laptop with us per se, we'll have an iPad with all that same information?
Correct. So you guys will still have the digital package that we provide to you guys, so you're able to.
But the digital package just has it doesn't have all the backup docs.
Correct. But moving forward, it will.
Okay.
We'll include all of those documents and the iPad itself. We actually have some printouts. Give me one second.
You're going to give us an iPad too?
Yeah.
Only for here. So I'm letting you take it home with you.
So these are just instructions, so you guys have it.
And this,
Here. That's iPad. It's not here. Yes.
So we get the package via email, and we're supposed to look at the package via email, then when we come instead of having the package, we'll have an iPad that you're gonna give us.
That is correct.
Okay,
Yes.
which is preloaded with everything.
Correct.
No more paper.
It was, yeah, you guys don't. Well, for the first month or two, we will still provide you guys with the package until you guys.
Because I know I was supposed to save one or two, and I'm not,
Yeah.
I'm not able to figure out which.
Yeah. Yeah.
Is this?
Yeah. The city commission uses it, yes.
So we're basically going to make any notes, and then we will bring our notes separate with us to reference back when we have the
Yeah,
iPad
you
with the
can.
full. Okay, got it. Handleable.
So does it mean you'll be reducing your departmental budget by the copying costs?
So actually, the applicants provide you guys with the copies. Yeah.
Ah, okay.
Yeah.
Fun.
it's burdensome.
Okay, anything else you have for us?
That's it.
Okay.
Tonight.
Do we have anything for the city commission?
No.
Anything for the good of the city?
Nope.
That all standing, we're adjourned. Thank you.
Thank you.
Thank you.